Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is the case of Puzio versus the state. Counsel for the petitioner is recognized.
Thank you. Good morning. May it please the court. My name is Ashley Kay and I represent David Puzio. Mr. Puzio was tried on 2 counts of first-degree murder for crimes that occurred in 1994 when he was 16 years old. The state sought the death penalty. At the penalty phase, Mr. Puzio's jury made a factual finding that David Puzio did not kill the victims, that the victims were killed by another individual, and that Mr. Puzio's participation in the crimes was relatively minor.
Counsel, can I ask you about that, what you characterize as a factual finding? Now, the jury was not actually asked to make a factual finding on that issue. Is that correct?
No, Your Honor. The jury, this was during the penalty phase since the state sought the death penalty. So the factual findings were mitigating circumstances that related to the facts related to the crime itself. So one of the choices that the jury could consider was number 1, which is.
But my question is, there's no place on the form presented to the jury, like with a blank, for them to indicate how they voted. Is that correct?
That's correct, Your Honor. However, next to the factual finding, the jury wrote the word yes.
Well, do we know? I mean, was the jury instructed in any way about what would result in something being written there? It just seems like a very odd thing to rely on that as a jury finding when in the context of this particular case, given that the jury was not instructed to make a finding on that and to vote on it. I mean, do we know how many people voted that way? Do we know whether the foreman just wrote that down there? I mean, I don't know how we understand exactly what that means. Help me understand that better.
Understood, Your Honor. I think as a quick threshold issue on that point, I would note that the state in its briefing to the 4th District, and I would submit here to this court as well, has conceded the factual finding by the jury, and that the 4th District Court of Appeal also acknowledged that this was a factual finding made by the jury. But to get to the heart of Your Honor's question, I think we can look to the larger context of the case. First of all, this was in the penalty phase. We know that the jury on both counts of first-degree murder came back unanimously, and at this time, the verdict did not have to be unanimous. The jury came back unanimously 12-0 for life. Next to the factors which the jury was asked to consider, and what the penalty phase instruction stated is, if you consider that this fact is if you are reasonably convinced that this fact occurred, you may consider it as established. And next to these factors, the jury wrote yes. I'd also note that when the jury was deliberating on the verdict, the jury sent out 2 identical questions, noting that there are 2 ways for which an individual can commit first-degree murder. One is premeditated, one is felony murder. We, the jury speaking, don't understand why we can't differentiate on the verdict form so we can make the distinction between first premeditated murder and felony murder. When the judge did not answer that question right away, they sent another question out saying, is there a question with a problem with our request to distinguish between first-degree murder, between premeditated murder and felony murder? So I think when you look at the case as a whole, this is a factual finding made by the jury that's really not in dispute. The 4th District has held as much and the state has conceded as much. And I think this factual finding by the jury, which the jury says is now established, precludes any argument from the state that they could show beyond a reasonable doubt that Mr. Puzio shot and killed the victims. We know that Mr. Puzio did not shoot and kill the victims because the jury made this finding. The problem occurred 21 years later at Mr. Puzio's resentencing hearing pursuant to Miller. And the problem is that at that resentencing hearing, we know the judge decided explicitly and unequivocally that Mr. Puzio shot and killed the victims and accordingly sentenced him under 1B1. And there are 2 clear problems with this finding by the court. The first, which we just discussed, it's that it's in opposition to the jury's factual finding. So if we go to the sentencing hearing, it's clear that every consideration and every factor that the judge had to determine and consider was viewed through the false lens that Mr. Puzio shot and killed the victims. For example, when considering 921-1401A, the nature and circumstances of the offense, and F, the defendant's participation in the offense, the judge considered those factors through the false and unconstitutional lens that Mr. Puzio shot and killed the victims. And this is in opposition to what the jury found. And the second problem, of course, with what the judge did by conducting the sentencing hearing under the decision that Mr. Puzio shot and killed the victims, the second problem is, of course, that's an unconstitutional finding in violation of Elaine and in violation of Williams. And on appeal, as I stated, the state conceded a harmful Elaine violation. They acknowledged the factual finding by the jury, and the state conceded that Mr. Puzio was entitled to a resentencing hearing. The Fourth District then held this is a harmful Elaine violation. The Fourth District held that the factual finding and acknowledged the factual finding made by the jury that Mr. Puzio did not kill the victims. But, and the reason we're here is the Fourth District held that Mr. Puzio wasn't entitled to a resentencing hearing, and we just needed a ministerial correction. But it's clear that with a ministerial correction, we're going to be left with three fundamentally capable problems. With just a ministerial correction, the judge's false conclusions and false factual findings are going to remain as part of the record. Every finding that the judge made, and they are many, that Mr. Puzio shot and killed the victims will continue to be the facts and findings of this case. And that's in direct opposition to the jury's findings. They're not correct findings, and they could affect Mr. Puzio at his review period. The second problem is that if we just leave it to a ministerial correction, the jury's factual finding, which the Fourth District has acknowledged and the state has conceded, will continue to be ignored. And the third, of course, is that the sentence will continue to be unconstitutional in violation of Elaine and in violation of Williams. The Fourth District originally did not give a reason for their ministerial correction remedy. It was only after the defense asked for rehearing and the Fourth asked the state to show cause that the state came up with this comment by the trial judge that the trial judge made in that comment 9 months after the sentencing hearing and after the trial court became aware of Williams. And using this comment, and the comment was, although I sentenced the defendant under 1B1, I equally find 60 years appropriate under 1B2, quote, in light of the facts of the case. And this was a major flip-flop by the state, who originally conceded that Mr. Puzio was entitled to resentencing. Now, of course, the state is advancing, and the Fourth District adopted the state's reasoning that Mr. Puzio is not entitled to resentencing because of this would have imposed test. But the problem with that is that it's the wrong harmless error test. There's more than one test, of course, this court knows. And the correct harmless error test for an Elaine violation is, does the record reveal that a rational jury would find beyond a reasonable doubt that the defendant intended, attempted, or actually killed the victim? That question has already been answered by the Fourth District when they stated it's a harmful Elaine violation, and already conceded by the state.
So counsel, I'm sorry to interrupt you, but in this case, the judge has already said that regardless, I understand that the order is written where the court clearly believed that Mr. Puzio was the shooter, but he also indicated that even if he were sentencing under B2, which by definition means he was not the shooter, the court still thought that the 60 years was appropriate. So what are you, putting aside the question of whether from a purely process perspective, there does need to be a remand and they need to, he needs to basically say the same thing again. What are you suggest? What is the court supposed to do? I mean, are you saying that the 60-year thing would be sort of presumptively invalid or arbitrary or illegal, or what are you expecting the court to do if the court has already said, even if he's not the shooter, I still say 60 years?
Well, what I'm asking the court to do here is to send the case back for a sentencing hearing, because Mr. Puzio deserves the constitutional opportunity in a constitutional sentencing hearing where a judge will first and foremost sentence him under the correct statute. But just as importantly, I would need, and Mr. Puzio is entitled to, a judge who's going to review all of the sentencing factors and take things into consideration through the correct lens that Mr. Puzio did not shoot and kill the victims. I think the comment by the trial court in the sentencing order is first and foremost irrelevant if we apply the correct harmless error test that this court laid out in Williams. If you apply the harmless error test in Williams, which is the test for harmful lane violations, also the test for harmful apprendi violations, also the test the United States Supreme Court uses for harmful apprendi violations. If you apply that correct test, a comment made by the trial court 9 months later in an order is going to be irrelevant, and that should end the inquiry.
Right, and your position, I'm sorry to interrupt you, but your position is that based on this notation on the jury form on the mitigating factor issue, which, as the Chief Justice suggested in his question, we really don't have any idea what exactly it means. I agree with you that it's a sort of an odd wrinkle here that's, that obviously we need to take into consideration, but you're saying that at the hearing, if it happens on remand, essentially the shooter issue is off the table solely because of that notation on that form.
Well, I think if we didn't have the jury's factual finding that Mr. Puzio did not kill the victims, we still have a harmful lane violation. So we would need to have a resentencing hearing. And that is based on the fact that the jury was instructed on both theories. The verdict form did not specify. The jury asked the two questions that I noted during deliberations. Why can't we differentiate between premeditated and felony murder so that we can make a difference? The evidence in the record as reviewed by the Fourth District pursuant to the harmless error test, the record at trial did not show that a jury would have found Mr. Puzio killed the victims beyond a reasonable doubt. And we can get into the heart and the facts of the trial, specifically the other individual in the car confessed to several people, was seen with a gun that night, and we can get deeper and deeper into the record. But presumably, the Fourth District reviewed the entire record in the case and determined that the lane violation was harmful. And one of the many things that they considered to determine the lane violation was harmful was this factual finding made by the jury that has not been disputed by the state, that has been conceded by the state at the Fourth District. So I think that's one factor, but and it's a powerful factor, and it's a unique factor to Mr. Puzio's case, but I don't think it's the only factor that allowed the Fourth to, yes.
If I could, everyone seems to agree that there was a Sixth Amendment violation that could not be deemed harmless under Williams, Galindez, that standard. And in Williams, we said that requires resentencing. That didn't happen here. So assuming that we send it back for resentencing, and in a normal case, so forget this very, very unusual case where there's an argument about whether there were jury findings on this sentencing factor, which you just normally wouldn't have in any other case. Would there be any double jeopardy violation in your view to allow the state in a normal case, we're not talking about your case, to impanel a new jury and go forward, and if they wanted to submit the issue to the jury, as Justice Kennedy argued should be the case in Williams and the dissent?
If we aren't talking about Mr. Puzio's case, and the question is whether Gaiman overrules Williams, which is what the state is saying this court did, or what the state is asking the court to consider, yes, I do think there are double jeopardy concerns in paneling a jury in the general
concerns. I'm not seeing them. So what are the concerns? Lay out for me why it would be a double jeopardy violation?
Well, when you look at a case, if you compare Gaiman to Williams and you look at a case like Gaiman where the jury has to determine danger, those two proceedings need to be bifurcated. The first proceeding, the jury can't hear any evidence of danger or that will prejudice them on reaching a verdict in the case. The second phase, the jury is going to consider only danger. It needs to be bifurcated. And at that proceeding, the jury is not going to relitigate or reconsider any fact or element that had to do with the qualifying offense, the original crime for which they found the defendant guilty. If you go to a case like Williams and those alike, again, taking Mr. Puzio's case out of it, you would have a jury who has already litigated and not litigated, excuse me, a jury who has already considered and determined the elements and facts of the crime and reaching their verdict of first-degree murder. They just didn't differentiate. So if you impanel a brand new jury, that jury will deliberate on the same facts and the same elements that were considered by the first jury in order to find, in essence, whether the defendant has committed the crime. And so because you have a second jury considering and going over something that's already been deliberated and considered by the first jury, you're going to have double jeopardy concerns. You're also going to have due process concerns. And frankly,
the way that the case was originally presented to the jury, this issue was not presented to the jury. Assume that it wasn't. I mean, in a normal case, it wouldn't be. Assume that it wasn't, because its only relevance is as a sentencing factor. It's not necessary to present the issue of whether the defendant actually intended to kill, that standard to the jury. So you have something that is only relevant as a sentencing factor, and there was a constitutional violation. There was an appeal. It gets corrected. The right correction is a new sentencing proceeding. So why wouldn't you present the sentencing factor to a jury?
Well, I think that as just a threshold consideration, I think this court did answer that, or that with the new jury instructions, for example, 7.3, we know that going forward, the jury is always going to decide intent in the situation like this. The jury is always going to decide intent, attempt, and actually killed at the same time that they reach a verdict of guilt or not guilty. And I think the reason for that we're never going to let this happen again, we're always going to have the jury make this determination in the guilt phase, are the double jeopardy concerns. Because even though they're not going to make the specific factual findings in cases pre-jury instruction 7.3 in these harmful Elaine errors and William cases, those deliberations inhere in their verdict. So
let me ask you this: what case establishes that would be a double jeopardy violation? Give me a case. Yeah, concerns are one thing. Give me law.
I think when you look at Galindez, you're going to have a problem there, because when you look at Justice Quintero's especially concurring opinion there, he notes and warns that, of course, any new jury that's going to be a sentencing jury,
especially concurring opinion. I mean, again, I'm asking for law, not a special concurring.
Understand. I think you can
if you don't have one decide, that's fine. But I'm just
okay. I think you can look at Williams v. State, the 1992 case that relates to the death penalty. That says that double jeopardy prevents the second penalty phase that would subject the defendant to an increased penalty. And I think you're run into those problems when you're impaneling a jury. But I think, again, if we're talking about that issue here, the state has waived that issue. That issue has not been properly briefed and argued. And I would submit that the court should not make this determination in Mr. Puzio's case. One, for that reason. Yes.
Counsel, you with our considerable help, have consumed a good part of your rebuttal time. You can keep going, but I'm going to give you 2 additional minutes for rebuttal, but be governed accordingly.
Thank you, Your Honor. I'll just say that I believe in terms of the impaneling a jury issue, that the issue has not been properly briefed, argued, and raised in the appellate process. And I would also note that in relation to Mr. Puzio, we will have a double jeopardy concern, and there is case law there, and I'll reserve for rebuttal and thank the court.
Thank you. Counsel.
Mr. Chief Justice, and may it please the court. Kevin Golombiewski for the state of Florida. I'd like to start with the double jeopardy concerns that counsel raised and also that the justices raised about impaneling a jury on remand. So first, as an initial matter, as Chief Justice Kennedy indicated in his questioning, the determination or the notes on the jury instruction form, we do not know the import of those, and we cannot conclude whether the whole jury concurred in those notes. But more importantly, as a matter of law, under Hurst v. Florida, at the penalty phase during the time of Mr. Puzio's trial, juries did not make findings. They made a recommendation as to life or death. And so the notes on the charge form cannot be considered binding findings, particularly for double jeopardy purposes.
So is Ms. K wrong when she says that you conceded below that these were factual findings?
I believe that Ms. K is referring to page 16 of our answer brief below. And there we use the phrasing that the jury found that Mr. Puzio was an accomplice, but we don't see that as a concession that there was a finding. But even if it was, as a matter of law, we couldn't have conceded that point because there just were not findings at that time by the jury at the penalty phase.
All right, so if it's not a finding, what is it?
It's just notes on a form, Your Honor. The jury wasn't, as Chief Justice Kennedy pointed out, the jury wasn't instructed to even make determinations as to aggravators and mitigators. It was given the jury charge form, which was sent back with it at the penalty phase, and it wrote notes. Someone from the jury wrote notes on that form. That might be evidence that's useful to determine what a rational jury would have done, but that's at most what it is. The jury didn't even issue a recommendation as to that point, Your Honor, let alone find.
By the statement that it's evidence, I'm not sure in what sense or what rule of evidence it would be admissible, but it seems to me that I'm not sure I'm familiar with any cases. I'd be happy for you to direct me to any cases saying that a statement on a form that comes back from the jury is something other than an answer to the question on the form. I have not heard of such a case, but if you've got one, lay it on me.
I don't have a case, Your Honor, but it wasn't even an answer to a question on the form. The form was just a charge. It didn't lay out any questions for the jury. And these were notes in the side of the jury charge form. And they're.
So is it akin, are you saying that it's akin to like a jury question? Should we treat it like we would treat a jury question that comes back from the jury and the trial court judge decides whether to answer it or not? Is that essentially what the state's position is?
No, Your Honor. Our position is that just like maybe there's a notebook or a binder sent back with the jury where it took notes throughout the deliberations process, that's the equivalent of what these notes are in the side of the jury charge form and nothing more. Importantly, we don't know, for example, even whether at what stage at the penalty phase these notes were taken. So we don't know if they were any final indication that the entire jury concurred in. So all at most they are notes that were taken back with the jury during their deliberation process.
Given this aspect of this case, wouldn't this be a less than ideal case for us to use to reconsider Williams on the remedy issue, on the re-impaneling a jury issue?
I don't believe so, Your Honor, because I think the law so clearly established that the jury at that stage did not make findings pre-Hurst, and these were just notes. So there is no double jeopardy issue presented. And in fact, in this court in Harris v. State, Johnson v. State, long ago even said, when a jury recommends life at the penalty phase, so there's actually a formal recommendation, there's no double jeopardy problem with the trial judge overriding that jury recommendation and imposing death. And so there you even have a clear, unequivocal recommendation from a jury, and there's still no double jeopardy problem. So
right. That's because ultimately as we've said in some of our other cases and other courts have said, the balancing issue is a judgment call that's not really a fact question. And here I completely understand what you're saying about the form, and Chief Justice Kennedy's questions pointed it out. We don't really know exactly what to make of the form. But it does seem like there are cases that say that the subsequent jury cannot contradict, the original jury without raising double jeopardy issues. I think that's fair, right? And in this case, there just is this, it seems like this case would not, to me, I'm not sure if this is the ideal case to reconsider that aspect of Williams, but I mean, you've responded to my questions / concerns.
And let me ask you this. So Williams does say that resentencing is the remedy, and there was no resentencing. Assume that we send it back for resentencing. Why wouldn't these issues about the specifics of this case and whether there is a jury finding that would preclude impaneling a new jury or a sentence that's inconsistent with those findings? There's a double jeopardy problem with that in this case. Why wouldn't those be issues to be raised initially in the trial court at resentencing?
I think that is completely fair, Your Honor. The double jeopardy issue, to an extent, isn't even ripe yet. This court can correct and clarify the law that impaneling a jury to make the B1 finding is appropriate to remedy an Elaine error. And if on remand, the state chooses to exercise its opportunity and impanel a jury, then Mr. Puzio can raise the double jeopardy concerns, and that can be fleshed out and addressed by the circuit court in the first instance. So I think that's completely correct, Your Honor. But it's imperative, and it is important for this court to address this issue. And I think this circles back a little bit to Justice Muniz's question, to address this issue about whether Gaimon or Williams is controlling. Because as we showed in our notice of supplemental authority, the DCAs are already split on this issue, with the 5th adhering to Williams and the 3rd DCA saying that Gaimon controls now and remanding to impanel a jury.
Do you agree with what Ms. Kay said about the distinction between cases where, like Gaimon, where the dangerousness finding, I think Gaimon was a credit card case or something like that. And, where really the dangerousness is completely distinct from what was at issue the first time around. In this case, I understand, as Justice Lawson was saying, there, whether he was the shooter may or may not be relevant, but it seems like in this context, there is much more of a possibility that there could be overlap between what the jury considers, in the first go round, and then what might happen subsequently if there's another jury looking at this question as to who the shooter is.
I don't agree with that, Your Honor. And so how I take the argument is, well, the finding here relates to the nature of the offense or the offense conduct. And so there's double jeopardy concerns. But in the Hearst context, for example, or death penalty more broadly, the penalty phase jury is making findings related to the offense conduct, for example, heinous, atrocious, or cruel, and other issues. And there's no double jeopardy problems there. Also, that the Gaimon situation, the subsection 10, is bifurcated typically, is irrelevant to the legal or the constitutional permissibility of having this B1 finding be conducted separately. So at bottom, the subsection 10, the dangerousness finding, and this B1 finding are functional equivalents of elements under Apprendi that are used to enhance a sentence. They're not part of the underlying offense that needs to be established for guilt. And so they can be treated the same, which means they can both be found at a separate bifurcated sentencing proceeding. And I'd also like to address, Justice Muniz, briefly your point about double jeopardy and concerns about the findings, circle back one more time, because in the SCOTUS precedents, one thing that's critical is finality. And here, when you have merely an advisory jury recommendation or findings, that doesn't have the finality attached to it that's necessary for jeopardy to attach. And so that's another reason we think that this case, the facts of it do not present those double jeopardy concerns. And I'd also like to make one final point on this double jeopardy, and then I'd like to jump into the harmlessness issue unless folks, the justices have other questions. But even if there was a double jeopardy problem based on the notes on the jury charge form, the state should still have an opportunity to seek a finding that Mr. Puzio intended to kill the 2 victims, which can trigger B1. As this court recognized on page 292 of Williams, when a defendant is intimately involved with a murder, there could be a finding that he intended to kill those victims, even if he didn't actually pull the trigger or wasn't the killer. And so here, because Mr. Puzio coaxed the victims into a car with him and his friends, directed them out to a deserted road where the victims were robbed and killed, a jury could, for example, find that he and his two friends intended to kill the victims, even if Mr. Puzio wasn't the actual killer. So regardless of the jury instruction nuance to this case, there's a basis for impaneling a jury on remand, in our view. And on the harmlessness point, Mr. Puzio's primary contention seems to be, well, if an error is harmful under Williams, it's harmful, period, and resentencing is required. But the test in Williams looks at whether an error is harmful at bottom to the man-man. If a jury would have not made the finding that triggered the man-man, then the error is harmful because the man-man wasn't inevitable and it shouldn't have been applied. But it doesn't follow from that test conclusively that the Elaine error infected the rest of the sentence. It could be the case, as it is here, that the error is insulated from the term of years, where we know it's harmful as to the man-man because a jury wouldn't have made that B1 finding. But if there's record evidence that establishes that, the judge would have applied the same term of years regardless. You could still have a situation where the error is harmless as to the term of years. And that's consistent with this court's other precedent in the score sheet context, or this court in the DCA's precedent in the score sheet context, the classification context, and even with man-mins, with the 3-year man-min for firearm possession. And I know that Mr. Puzio talks about there's this different harmlessness standard for Elaine errors, and that's Williams. But the same harmless error principles apply across the board, and the test just manifests differently. And so this court's test for harmlessness in DiGiulio and then the legislatures in section 92433 still govern. And the driving principles are appellate court should not disturb the work of a trial court unless necessary. And so if an error is insulated from the term of years and resentencing would just be a pointless proceeding, the sentence should not be disturbed. And
was it given that the case was sent back to the trial court to state the reasons, I guess, under B3 as to why under B1 the sentence was what it was it appropriate for the court to just sort of have the sort of, throwaway line in there about even under B2, I would have done the same thing? I mean, should that matter to us?
No, Your Honor. So in our view, the scope of relinquishment just doesn't matter for purposes of harmless error review. And we see this issue as a bit of a red herring. What matters for harmless error review is what's in the record. So section 92433 and DiGiulio say that the courts, in examining whether an error is harmless, should look at the record as a whole. In section 92433 says, look at the appeals papers. And this statement by the trial court is a part of the record. That's something that Mr. Puzio has not disputed. In fact, he supplemented the Fourth DCA's record with that sentencing order. And so because it's part of the record, it's record evidence that the Fourth DCA properly considered. And whether it was within or without the scope of relinquishment is just irrelevant. It wasn't an exercise of authority. This is evidence and an evidentiary issue for the appellate courts to consider as part of their harmless error review. And so there's one other point I'd like to briefly address, and that's Mr. Puzio's claim that the trial court's determination that 60 years should apply no matter what is infected by the trial court's determination that Mr. Puzio was the shooter. The trial court's statement belies that claim because the court said that whether B1 or B2 applies, 60 years is appropriate. And the distinguishing feature between B1 or B2, of course, is those findings about whether the individual was or was not the shooter. So the court was assuming whether or not Mr. Puzio was the shooter, it's appropriate to impose a 60-year sentence. And I think underscoring the problem with Mr. Puzio's argument that this court should just ignore the trial court statement altogether is the practical import of that argument. This case would be remanded to the same court that has already said it would impose a 60-year sentence for resentencing proceeding in which the victim's family would again have to come and testify 25 years later after the crime, all for another 60-year sentence, because we know the trial court, based on that record evidence, would impose it again. And that's the type of pointless resentencing proceeding that harmless error review is designed to guard against. And so unless the court has any additional questions, I'd complete my argument there. Thank you, Your Honors.
I mean, I'm just having a hard time following that logic. I mean, if the remedy is a new sentencing hearing, then the defendant would have an opportunity to present whatever at that hearing, correct? To try to sway the judge as to the appropriate sentence, correct?
If the remedy was a completely new resentencing hearing?
Yeah.
Yes, Your Honor, that's
so
correct.
if you send it back for resentencing, which Williams says you do, then at the sentencing hearing, the defendant has a right to be present and has a right to present whatever the defendant wants to present that bears on the appropriate sentence, correct?
That's correct.
Okay. Did that happen here?
The defendant had an opportunity to present evidence, and he requested that the trial court look to the trial court record below, including the penalty phase and the doctors and experts that testified on his behalf. And so he had an opportunity to present his case.
He had a sentencing hearing, the order that where the judge said that he would give the same sentence. You viewed that as a sentencing hearing, so he's already had that opportunity?
Oh, Your Honor, no, I misunderstood your question. He had a sentencing hearing before that, Your Honor.
Right.
Before relinquishment.
And then there was a violation, a Sixth Amendment violation, and Williams says he's entitled to a new sentencing hearing, which means the defendant's present, correct?
That's correct.
Okay, and it means the defendant can present whatever evidence the defendant wants to present that bears on the appropriate sentence, correct?
That's correct.
Okay, so has the defendant had that opportunity?
Yes, he has had that opportunity in the first instance in the resentencing.
Has he had an opportunity after the determination that there was a Sixth Amendment violation that required resentencing?
He did not have that opportunity after the Sixth Amendment. That's correct, Your Honor. But
so,
he had
how can the judge simply saying, well, I would do the same thing, be sufficient to say, okay, well, we just don't care. He doesn't get the opportunity that we've said he should get in light of a Sixth Amendment violation. I'm not following your logic on that at all.
Well, based on the defendant had his resentencing hearing post Miller. He had an opportunity to present evidence and mitigation, and the trial court also had the benefit of being the judge that presided over the original trial. And so the judge has considered the universe of evidence relevant to sentencing, and he's concluded that 60 years would be appropriate no matter what, given the circumstances of this case. Now, the judge might not have had a subsequent hearing after the Lane error, but based on the judge having reviewed the universe of relevant evidence and concluding that 60 years is appropriate no matter what, it's our view that that's conclusive evidence that if you go through a resentencing hearing and Mr. Puzio has another chance to make his case for the third time after his penalty phase and this resentencing, things aren't going to change. The judge has already considered that whole world of evidence that's available.
In the first go round, did the defendant argue as part of the resentencing that he wasn't the shooter?
Yes.
So that was already, so that's your point, right? Is that whatever the merits of those arguments might be, the judge has heard them. The judge also saw the trial. And so it's not as if there's going to be a whole new issue that's going to be presented to the court as a result of the Sixth Amendment violation, right?
That's a better way of putting my point, Your Honor. Yes, and that's correct. The judge has considered that he was the shooter, the evidence that he was not the shooter, and also looked at the other evidence in mitigation. And so at bottom, just the practical consequence is if there's a whole nother resentencing proceeding, the judge is going to be presented with evidence that he's already seen and already has ruled that 60 years is appropriate no matter what. Well, thank you, Your Honors. I'll conclude my argument. Thank you.
Thank you. Rebuttal.
Thank you. First of all, the judge absolutely never considered the possibility that Mr. Puzio did not shoot and kill the victims. And one only needs to look to two things: the sentencing transcript and the sentencing order 9 months later that contains the comment about would have imposing the 60 years. If you look at that sentencing order, the judge describes why he would have supposedly given the same sentence. He says the same sentence is appropriate under 1B2, quote, in light of the facts of the case, which begs the question, what are the facts of the case according to the trial court? That question is answered from the judge's own writings and his own transcript in the sentencing hearing. The facts of the case that the trial judge believes is that Mr. Puzio shot and killed the victims. He considers those, quote, facts established at trial. Those facts are false. In detail in the sentencing order, he states that Mr. Puzio killed the victims over and over again. He considered no other scenario, and those facts infected the entire consideration. Mr. Puzio is entitled to a new sentencing hearing for a judge. This particular judge is retired from the bench, but if it was going to be in front of this judge or another judge, that judge needs to view the sentencing factors A through J and everything else through the correct lens that Mr. Puzio did not shoot and kill the victims.
So
Second,
I'm sorry, counsel, I'm sorry to interrupt you. When you say considered, you mean that the court in its own mind viewed Mr. Puzio as the shooter. You don't, and then ruled accordingly. You don't mean, when you say considered, you don't mean that the court didn't hear arguments from you as to, and evidence from you as to why, from your perspective, he wasn't the shooter.
Well, he listened to there was a I was the lawyer there, and there was a threshold argument of whether the client Mr. Puzio should be sentenced under 1B1 or 1B2. And I actually made an Elaine argument knowing that Williams was pending before the court. And the judge at that point decided that Mr. Puzio was the shooter. And so and that he was going to make that decision. In fact, the first thing the trial judge said when we got into the courtroom was, didn't he confess? And that actually never happened. That's not true. And the trial judge continued to view the hearing. So once the trial judge made that initial determination, no matter what I said or the defense attorney would have said on A through J, the sentencing factors, participation, nature and circumstances of the offense, that was never going to be considered through the lens of anything else other than the judge's false conclusion and unconstitutional conclusion that Mr. Puzio shot and killed the victims. And if there's any doubt if that was considered, we only need to read the sentencing order. And one would see that every fact, everything that the judge believed is that Mr. Puzio shot and killed the victims. He did not consider another scenario. I also note that the state—
Counsel, you now have exceeded your time. If you could sum up in about 30 seconds.
Yes. I would note that the state has absolutely conceded in their answer brief that the jury made a factual finding that the defendant, the offense was committed by another person. The defendant did not shoot the victims and kill the victims, and his participation was relatively minor. That fact was acknowledged by the state, and it was found by the Fourth District. This is a harmful error. It cannot be cured other than a constitutional resentencing hearing to give Mr. Puzio that chance that he deserves under the Constitution. And in paneling a jury has not been properly argued or briefed in this case. And in Mr. Puzio's case, it will absolutely violate double jeopardy. We will force the jury and give the state an opportunity to try to convince the jury of a fact that has already been explicitly rejected by Mr. Puzio's jury. And the state conceded that fact, and the Fourth District conceded that finding as well. So the only constitutional thing that should happen is the resentencing.
You have long exceeded your time.
Thank you, Your Honor.
Okay, thank you. We thank you both for your arguments in this case today, and the court will now prepare for the consideration of the second case on our Court will now proceed to the second case on today's docket, Sheffield versus Rj Reynolds Tobacco Company.
Good morning, and may it please the court, David Sales for the petitioner, Mary Sheffield. This court should quash the decision of the district court for two independent and independently sufficient reasons relating to the text of the statutory amendment in question, which applies only to causes of action arising after October 1, 1999. The first reason is that Mrs. Sheffield is pursuing the same tort causes of action pursued on her late husband's behalf by the Ingle class. Because they are the same causes of action, they could not have arisen after the effective date of the amendment. The second is that these same causes of action arose within the plain and ordinary meaning of the term no later than 1994, when Mr. Sheffield had a fully mature right to sue Rj Reynolds Tobacco Company for a smoking-related lung cancer. In Douglas, when considering the causes of action pursued by an identically situated litigant, that is to say, a widow, acting as her late husband's personal representative, this court held that she was pursuing the same causes of action as the Ingle class against the same defendant, a point that the court actually italicized for emphasis at 110 Southern 3rd 432. The court's use of the term fits perfectly when measured against the survival statute, which also refers to causes of action, not actions. That's section 46.021 of Florida statute. It states, no cause of action dies with the person, all causes of action survive. And thus by statute, when Mr. Sheffield died, his causes of action did not die with him, and the statute could not be any clearer on that point.
But that's referring to that's referring though to causes of action that aren't related to the death, right? Doesn't 768.20 say that when a personal injury to the decedent results in death, no action for the personal injury shall survive?
Right, and that's a key point, Justice Muniz, because it doesn't refer to causes of action, it refers to actions. And that is a term of art used in our law that describes a lawsuit, not the cause of action or the theory or claim that was being pursued. And I think if you actually take a look at the entirety of the text of 768.20, which both parties cite, you'll see the point. It says no action for the personal injury shall survive and no such action shall abate, not causes of action. And this court's decision in Capone, of course, tells us that abate does not mean extinguish, as the defendant suggests, but rather paused until the decedent's representative takes the decedent's place. And if you actually read the entirety of the section, when it talks about what happens when the defendant dies, it confirms the point, because the statute also provides that if the defendant dies, his representative, quote, shall be the defendant if the wrongdoer dies before or pending the action. This makes perfect sense because a dead person under our law cannot prosecute or defend a lawsuit. But in accord with the most common usage, the most customary usage in the way lawyers and judges should speak, an action is the suit, and it is what gets transformed upon the death of the injured party. But the causes of action, if you read these statutes together, the only way to read them together, as this court effectively did in Capone, is to say that the statute, that the survival statute prevents the death of the cause of action.
How do you, yeah, counsel, let me ask you this. Don't we have cases that refer to wrongful death causes of action?
You absolutely do. I think what this points out is that there's a high degree of imprecision. You have cases, not just from this court, but from the district courts of appeal and elsewhere, that speak of counts and claims and causes of action and rights of action. And they treat those terms synonymously. But the Florida legislature, when we're looking at the statutes that matter in this case and the plain text, the most important statute, of course, is the one under consideration, and it speaks of causes of action. And the survival statute, which sets forth the interplay, as this court has already held in Capone, with the Wrongful Death Act, also uses the phrase causes of action. So I would submit to Your Honor, yes, that is true. And I'll give Your Honor a perfect example. Last year, this court decided a case called Barnett. And in that case, tragically, the court will recall the shooter shot 5 kids. 4 died and 1 lived. And the court actually set about the business of setting forth the cause of action for the claims that arose in that instance. And what the court said is the cause of action in tort was based on the familiar elements of duty, breach, causation, and damages. Damages plural. It didn't distinguish between the damages that arise when someone lives and someone dies. And if we were to ask a law clerk or a young lawyer to go search the entirety of Florida statutes and find us the case that sets forth the elements for a wrongful death cause of action, we'd be hard pressed to find any such case, because cause of action in the technical and most correctly used sense means just what is suggested by the survival statute. I think that if the court turns, and we've cited this as supplemental authority, the recent decision, the unanimous decision of the United States Supreme Court by Justice Thomas to what a cause of action is, it actually directs us to consider the universe of operative facts. Sometimes we refer to the same transaction or occurrence. That's what provides the cause of action. And yes.
Isn't it true under your rule then that as long as I live, I have a cause of action for my wrongful death someday, if it ultimately is found traceable to some injury I suffered? I'm trying to come up with a limiting principle to define the bounds of the cause of action as you've defined it before the court, and I struggle to do so, frankly.
I think that the boundaries of it and the limitations are imposed by the statutes and this court's prior decisions, including Capone, including Martin, including United Security. And let me give the court an example, if I can, Justice Coriel. Let's suppose I'm involved in an automobile accident in which my car is totaled and I suffer an injury. We don't say I have a cause of action for property damage. What we say is I have a cause of action in negligence. And we do not properly say, although judges and lawyers certainly use these words loosely to this effect, we don't properly say I have a new cause of action or my estate has a new cause of action if my injuries lead to death. It's the same cause of action. It's a cause of action for negligence. And in that way, if you think about the court's prior decisions in Martin and also in United Security, the court essentially held, and it's correct, that there's something different about punitive damages. It is in fact similar to the property damage claim that I just mentioned, because it devolves to the estate unaffected by the death of the decedent. And that's what this court has held. This court cannot affirm, cannot uphold the decision of the Fifth District without effectively receding from that very important part of both Martin and in United Security. And to remind the court said that Martin was correctly decided essentially when it relied on that in the Capone case. These causes of action that are identified by the Fifth District effectively are not separate causes of action as well. But even if it were the case that those terms are loosely referred to and frequently loosely referred to as somewhat synonymous by courts and judges, the key facts here, the statutes upon which the parties rely, are 46.021, and that statute says that the cause of action doesn't die. 768.20 says what dies with the decedent is his action.
Mr. Sales, let me ask, what we're talking about here is a wrongful death action brought by your client. Could the legislature have made an amendment that said no punitive damages will be awarded for any wrongful death actions arising after October 1, 1999? Could they have enacted a statute that said that?
Could they have said that there would be no punitive damages awarded for any cause of action arising after that date?
Or for any wrongful death actions arising after October 1, 1999?
For any wrongful death action and not cause of action.
Yes, could
I
they
think
have said
you're
that?
asking, the parties are sort of, the short answer is I think that the legislature could do that constitutionally. In the district court, I will concede that we followed the lead of some of the DCAs in teasing out the question as to whether there was a constitutional impediment to doing that, but we're not arguing that here. We're arguing about.
I understand, but hypothetically, they could have done that. So had they done that, how would that have applied here? In this
How would
case,
it have, if the legislature had said, we abolish your ability to pursue punitive damages effectively for this
that
cause of
for
action?
any wrongful death action arising after October 1, 1999, there shall be no punitive damages award. How would that statute have applied in the facts of this case?
I think the result would be the same, and that's the second and most that's the second point that I wanted to discuss with the court today, that the term arising is the term that appears in the statute and not accruing. And if you trace the district court's decision that accruing and arising always mean the same thing back to its origin, it's actually the borrowing statute, section 95.10, which does have the word arise in it, actually arose, that the district court, the third district, considered in Meehan, where it held that the terms were synonymous. But this court quashed the third district on that precise point. And in fact, the third district, if you look at just Judge Schwartz's dissent, split 4-4 in bank on the precise question. The defense suggests that this is some sort of powerful read upon.
I'm not sure I'm following your answer to my question. So
the answer is, if it's arise, the plaintiff should still win in this case because the causes of action that are in play arose long before 1999.
So, but if it pertains to a wrongful death action specifically in the statute under my hypothetical,
right? Because our cause of action, our wrongful death claims, I'll call them, arose prior to 1999. That is the point about Meehan. This court quashing the third district's decision in Meehan, where the statute does use the word arose. If you applied the reasoning of the fifth district to this court's decision in Meehan, where the court found that all three asbestos claimants' cases, I'll call them for the moment, arose for purposes of the borrowing statute, which calls it causes of action, by the way, before the causes of action actually accrued, then the results in those cases were wrong. And the reasoning of the court is wrong because, as we point out in our brief, a cause of action absolutely can arise.
In that case, not about when they arose, but the where they arose and the connections with the state where they arose?
Both yes and no, I would say, Chief Justice Kennedy, and here's the reason why. Because those cases involved an exposure over many decades to asbestos. So it is true that in analyzing the where, it was important to know that where that occurred. But the third district in Meehan wasn't relying on it for that purpose. And the fifth district in this case is involved in a case where it's relying on the third district's reasoning in a case where it's the point in time that matters, not the place that the cause of action arose. So yes, both of those things can be true. But if you let's take, for example, the cause of action.
It's hard for me to understand why a cause of action for a wrongful death could arise before there's a death. How is that possible?
Because of the ordinary and common definition of the word arise, which means we are to look to the origin or to the source of the claim. And I would add, just for the moment, we don't concede. In fact, we heavily dispute that because of the operation of the survival statute, the cause of action writ large is the same cause of action as was pursued on behalf of Mr. Sheffield by the Engle class. And what the district court did was it substituted effectively the word accrue. Accrue has a very particular significance. It most commonly and most purposefully refers to the point in time at which a statute of limitations begins to run. We're not here on a case where there's any issue of limitations. And it was wrong for the district court, just as it was wrong for the third district in Meehan to conclude that arise means the same thing as accrue. So
counsel, if we look at the whole body of the law, isn't it going to be true that most cases where there is a reference to when a cause of action arose will be to when the cause of action accrued? They're essentially synonymous. I mean, if you just look again, you just look at the whole body of the law and you look for that phrase, isn't that going to be the case?
Sure. An obvious example.
You don't really
is-
dispute. I mean, I think even your briefs, you don't really dispute that.
Sure. Car wreck, broken leg, arise and accrue. But as the court recently discussed in the new life cases, there's a non-trivial number of cases for which there is delayed discovery, some of which, two of which, by the way, happen to be causes of action pursued by the plaintiff in this case. One is product defect cases and one is fraud cases. And what the court said was, which the statutes provide for, is that there is delayed discovery for accrual purposes when we're talking about limitations. That is to say, it is undeniable that a cause of action for product defect, Meehan is a perfect example, can arise before it accrues. If that were not so, the decisions in Meehan would not make any sense. Other examples where causes of action can arise before they accrue are instances in which the statute of repose applies. By definition, statutes of repose will extinguish a claim when it comes into existence, even if a cause of action has not accrued for purposes of the statute of limitations.
Now, counsel,
Yes.
I've pushed you over into rebuttal time. I'm going to give you an extra minute of rebuttal so you can continue or reserve.
I'll reserve the remainder for rebuttal. Thank you, Chief Justice.
I'm sorry, Counsel, can I ask you one question? So
Yes.
if we're gonna kind of try to push aside, the language in our case law that may or may not have been sort of thought out in relation to cause of action versus action, whatever, and we're gonna really focus just on the text, how do you even get punitive damages and once the action becomes a wrongful death action? If I'm just looking at the damages that are allowed to be recovered, and it says that the estate can get the damages caused by the injury resulting in death, and then the statute sort of has this what appears to be a comprehensive listing of the available damages. Why are punitive damages not just completely off the table anyway?
Well, I think the short answer to that is because this court has held that a death following an injury, if the original conduct, which would have supported a cause of action, a claim, I'll call it, for punitive damages, that does not die with the person. The court has expressly held that in two cases, and I don't think the defense.
But that wasn't in the first one. It seemed like it was potentially textual, but once the new statute came into effect, the decision didn't seem to me to be based on the text at all, and it was just a sort of, we agree with the quote unquote public policy rationale from what we said a few years ago.
I disagree with that. And it's important to note, going back to what I said a few moments ago, that the survival statute was actually amended at some point in the 1960s to change what existed previously, where the defense might have a better argument, to say that no action shall survive. And now it says no cause of action. And I disagree with Your Honor that it was just policy that drove the decisions in those cases. True, the court said what it said about it not making any sense, but I've already conceded, and we're conceding before this court, that the legislature could do that if it chose to. It could say that that wrongful death claims don't avail themselves to punitive damages, but no one in this case is making that suggestion. And just before I leave this,
Hey, I'm sorry, I've taken up more
no, it's all
time.
right. I would disagree also that anyone is pushing aside these references to wrongful death causes of action. They're relying on the settled meaning canon. And I would just ask this, where is the case where this court decided, for purposes of an issue similar to this case, where is the decision that there is a common law of the meaning of the word arise, where is the case that is construed, where this court has construed the meaning of the word arise? The only cases are the Lumberman's case and the Meehan cases, which, as I say, on the question of when the causes of action arose, this court actually quashed those decisions. And I would like to reserve the remainder of my time, whatever it is.
You'll get 5 minutes, counsel.
Thank you.
All right. Counsel?
Mr. Chief Justice, and may it please the court. The 1999 amendments apply to all causes of action arising after October 1st, 1999. Here it's clear that Mrs. Sheffield's wrongful death cause of action arose in 2007 when her husband died for three basic reasons. First, in plain English, the wrongful death cause of action doesn't arise until the person dies. As this court held in Barnett just last year, Arise means to begin to occur or exist or to come into being. And under that definition, the cause of action doesn't arise until it can be brought. That is, until its last element accrues. Here, that's when Mr. Sheffield died. Second, Mrs. Sheffield's position rewrites the statute to apply only where the tortious conduct arises after the effective date. But that's not what the statute says. The word arise modifies cause of action, not tortious conduct. So it applies whenever the cause of action arises after the effective date. And third, our position makes perfect sense. Any effective date provision means the statute applies to some cases and not others. Here, Mrs. Sheffield will be fully compensated for her injuries, but the legislature concluded that successive punishments were bad policy. And so it implemented that policy to the maximum extent possible without raising retroactivity concerns by applying it to all causes of action that arise after the effective date. I think this case is a perfect illustration of that policy choice. Reynolds has already paid almost $500 million in punitive damages in just 65 Engel cases alone. The legislature rightly determined that that was more than sufficient to satisfy its interests in punishment and deterrence. But I was surprised to hear my friend, Mr. Sales, rely on the Barnett case, because Barnett specifically addresses when a cause of action arises. And here's what it says, I'm quoting it. Arise is defined as to begin to occur or to exist or to come into being. Because the claim does not come into being or begin to exist until the last element accrues, the text is most reasonably read as including the incident or occurrence that caused the last element and the cause of action to accrue.
What do you make of his distinction between a cause of action and an action?
Well, Your Honor, I think that there's no distinction because this court has repeatedly made clear that the Wrongful Death Act creates a separate and distinct cause of action. The Wrongful Death Act itself says that when a personal injury results in death, no action for the personal injury shall survive. But there are legions of cases from this court that explain what that statute means. And I'll point you to Toombs, but Toombs cites many, many others. What Toombs says is that a wrongful death cause of action is, and here I'm quoting, an entirely new cause of action in an entirely new right for the recovery of damages suffered by them, that is the survivors, not the decedent, as a consequence of the wrongful invasion of their legal right by the tortfeasor. So it is quite clear that a wrongful death cause of action is separate from the personal injury cause of action.
Well,
The
counsel,
only question is,
let me ask you this. I mean, I'm following all you're saying, but isn't the reality here a little complicated because we've said that about the Wrongful Death Act and claims under the Wrongful Death Act, but there is this underlying reality of that the claims that are made there are derivative of claims that the decedent had, and isn't it true, for instance, that if the decedent had a claim that could be ultimately be brought as a wrongful death claim, but during the decedent's lifetime, the decedent fails to timely bring his own claim, then it's gone. Is that accurate?
yes, Your Honor, and that simply reflects the fact that under the Wrongful Death Act, one element of a wrongful death cause of action is that the decedent could have successfully sued for personal injury had he lived. And that one element would fail for the reasons Your Honor identified. But none of that changes the fact that the wrongful death cause of action is still, as this court put it in Toombs and many other cases, an entirely new cause of action in an entirely new right. And here, that cause of action didn't arise until Mr. Sheffield died. I'd like to point out that even if you look at Mrs. Sheffield's non-Florida cases on the arise accrue distinction, they lead to the same result. I'm not at all sure those cases are consistent with Barnett, but I'm quite sure that they're not inconsistent in a way that matters to this case. Because what those cases say, and they all involve the delayed discovery rule, what they say is that a cause of action arises the moment its substantive elements spring into existence, even if it might not accrue until a later point in time when the plaintiff discovers those elements through the exercise of reasonable due diligence. So for example, Conrad against Hazen is the New Hampshire Supreme Court decision that they rely upon. And here's what it says, quote, "A cause of action, therefore, arises once all the necessary elements are present." And it then continues, "While the action may not accrue until the plaintiff should reasonably know of the damage, it has arisen." Well, if you apply that standard to a wrongful death cause of action, it is quite clear that it doesn't arise until the person dies, since death, after all, is an essential element of a wrongful death cause of action.
Should we try to see though if there's a distinction between the survivor's claims and the estate's claims? In terms of, it seems like some of the language in our cases talks about how, the survivor's claims are the ones that really are the wrongful death claim, and the estate's claims are really just a continuation of whatever the decedent had before he died. I'm not saying that that's right, but
Yeah.
I'm curious what you think about that.
Well, no, you're not, for a number of reasons, Your Honor. First of all, you only have a survival claim if injury doesn't result in death. If the personal injury does result in death, then the survival claim is gone, and what you have left is a wrongful death claim. And I think that's why, and I'm recalling that during the early stages of this litigation, there was actually both a survival claim and a wrongful death claim in this case, but that the parties stipulated that smoking is what caused Mr. Sheffield's death, and therefore the only cause of action that went to the jury was the wrongful death cause of action. No survival claim, no survival cause of action was submitted to the jury. So the only cause of action that's at issue in this case is a wrongful death cause of action. So the only question then is, when did that wrongful death cause of action arise? And it wasn't until Mr. Sheffield died in 2007. Look, the legislature could easily have written this statute in the way that Mrs. Sheffield wants. A typical statute of repose isn't tied to when the cause of action arises. It's tied to when an underlying event occurs. The court explicitly explained that distinction in Cush against Lloyd, where it said, this was a 1992 decision citing a DCA 4 decision, that a statute of limitation runs from the date the cause of action arises. That is the date on which the final element essential to its existence occurs. It then specifically distinguished that from a statute of repose, which it said, quote, commences from the date of an event specified in the statute, such as the delivery of goods, closing on a real estate transaction, or the performance of a surgical operation. They easily could have written this statute using the language of a statute of repose and said that it applies whenever the initial injury or the tortious conduct arises after the effective date. But that's not what they said. They said it applies whenever the cause of action arises after the effective date. And to put it simply, a wrongful death cause of action doesn't arise until the person dies. I'd like to address, I'm happy to answer any questions your honors have, but I would like to address Mr. Sale's argument about the Lumbermans and Meehan cases. And I think that Chief Justice Kennedy, you were absolutely right. All those cases say is that in interpreting Florida's borrowing statute, the borrowing statute incorporates basic common law, choice of law rules. But those choice of law rules are utterly irrelevant to the determination of when a cause of action arises. That rather is governed by the plain language of the statute, as this court explained in Barnett, and it doesn't arise until the cause of action can be brought. I can illustrate the point by using the Lumberman's fact pattern as an example. You may recall that in Lumberman's, you had an insurance contract that was entered into in Massachusetts in, I think, roughly around 1970. And then you had a car accident that occurred in Florida in roughly 1980. And there was an insurance coverage dispute between the parties. What this court held in Lumberman's was that the law governing the contract was the Massachusetts law, because that was the place where the contract was entered into. But I would submit that nobody would say that the incurred insurance coverage dispute arose in 1970, 10 years before the accident occurred. That's just not how people talk. Just like nobody would say that a wrongful death cause of action arose 10 years before the person died. That's just not how people talk.
Could you address the relation back theory that on an amended complaint so that it would relate back to an earlier date?
Sure, Your Honor. I'd be happy to address that. And I think that the relation back doctrine is simply irrelevant to this case for multiple reasons. First of all, the relation back doctrine applies when you amend a complaint to add a new cause of action. Here, Mrs. Sheffield's first individual complaint already included the wrongful death cause of action because it was filed after her husband died. Put that entirely to the side. Even if you think that the relation back doctrine isn't gone for that reason alone, all the relation back doctrine says is that a new cause of action is timely if it relates back to an old cause of action. But it doesn't change when the new cause of action arises. And here, the new cause of action didn't arise until Mr. Sheffield died in 2007. And finally, Your Honor, the relation back doctrine is a procedural rule. So it doesn't change the substantive law that applies. It simply makes a new cause of action timely in certain circumstances. Well, here, the substantive law that was in effect at the time that Mr. Sheffield died were the 1999 amendments, since after all, they went into effect some 8 years after Mr. Sheffield died. So I think for all of those reasons, the relation back doctrine is irrelevant. And that may be why my friend, Mr. Sales, didn't invoke that doctrine in his affirmative argument. I'd also like to address the Martins and Capone cases that my friend relied upon. All those cases do is explain that the Wrongful Death Act eliminated the cause of action that used to be able to be brought under the old survival statute and incorporated it into a new wrongful death cause of action. So now what you have where injury causes death is a wrongful death cause of action instead of two overlapping causes of action. But what emerged from that legislative process was a separate and independent wrongful death cause of action. As this court put it in Toombs, an entirely new cause of action in an entirely new right. So again, the question is, when did that entirely new cause of action arise? And it wasn't until Mr. Sheffield died in 2007. Mr. Sales didn't raise the retroactivity issue, but I would like to address the retroactivity issue. Our position does not result in a retroactive application of the law, and even if it did, it wouldn't matter. It doesn't involve a retroactive application of the law because it applies only to causes of action that arise or accrue after the effective date. Nobody has a vested right in an incoherent cause of action. That is a cause of action that has not yet accrued. And so applying a statute to causes of action that accrue after the effective date is precisely how you avoid making your statute retroactive. But secondly, even if somehow you thought that our position was retroactive, and it's clearly not, it wouldn't matter. Because in Gordon against State, this court made quite clear that punitive damages are subject to the legislature's plenary authority. They can completely eliminate them if they want to, as long as they're not disrupting a final judgment issued by a court. So you actually can apply them retroactively subject to that final judgment limitation. So our position isn't retroactive, but even if it was, it wouldn't matter. Your Honors, I'm happy to answer any additional questions that you have, but if you
let me ask you on that point, how does Mancusi fit into your analysis?
Yeah.
What the court said there about clarity and so on.
Mancusi is irrelevant for a couple of reasons, Your Honor. Mainly, it applied the presumption against retroactivity to the retroapplication of an ambiguous statute. Here, our position isn't retroactive, and the statute isn't ambiguous. And in any event, Mancusi never addresses the constitutional question. It's purely a question of statutory construction. Because it was faced with an ambiguous statute that was being applied retroactively, it applied an ambiguity resolving canon to resolve that case and thereby avoid the constitutional question. But it didn't at all purport to overrule or be inconsistent with this court's clear statement in Gordon against State that punitive damages are subject to the legislature's plenary authority. I think the main objection that my friends on the other side have raised, at least in their briefing, is not so much an objection to our textual reading of the statute, but a policy objection. And they point to the apparent unfairness of not allowing punitive damages in a case like this. But what I would say is that anytime a legislature draws a line through an effective date or otherwise, there are going to be some cases that fall on one side of the line, some cases that fall on the other side of the line, and it might strike some people as unfair. But here, the legislature made a fundamental policy choice. What it said was, we do not like successive punitive damages awards. We don't like them in the future. We don't like them in the past. And the way that the legislature implemented that policy was the way that you traditionally implement a policy in order to give it maximal effect without raising retroactivity concerns. And the way you do that is by applying it to all causes of action that arise or accrue after the effective date, precisely what the legislature did here. But where I would conclude is where I would begin, the text of the statute, which after all is the most and arguably the only relevant evidence of what legislative intent was and is. And here, the legislature explicitly said that this statute applies to all causes of action that arise after the effective date. As this court squarely held in Barnett just one term ago, the cause of action doesn't arise until it exists. And a wrongful death cause of action doesn't exist until the person dies. For that reason, we think that the Fifth DCA got it exactly right, and it ought to be affirmed. I'm happy to answer any other questions Your Honors have.
All right, we thank you. Rebuttal.
Yes, thank you, Your Honor. Our argument before this court is primarily textual. It is the defendant who has come into court and talked about how much they've had to pay and why this court should agree with their construction of a statute, the meaning of which is in dispute. We're not making a policy argument today. We're telling the court that a cause of action means something and it's different from an action. And if one lays the survival statute against the wrongful death statute, where it refers to action, and lays that against the statutory amendment in question, the court should conclude that there is a difference and that they have a different meaning. Their argument is the policy argument, not ours. I want to talk very briefly about Martin, because in their briefs and here today, they really give those cases short shrift. If the court is going to recede from them and say that the survival statute means something else, it could do so, but it considered the meaning of the survival statute in those cases, and it considered the merger of the claims for personal injury brought about by the Wrongful Death Act. And it said in the opinion, just as an example in Martin, citing cases from Mississippi and Colorado, that the death of the injured party does not terminate the right to recover punitive damages, of course, the right that existed at that time, from the assailant, absent a statutory provision otherwise. It also said principles governing punitive damages are fundamentally, answering your question, Justice Curiel, the same as if the defendant were living. They don't even mention Atlas Properties in their brief, which is the case from which these principles arise. But if you look at Martin, where the court then described the facts of the case, it went on to say, if these allegations were established, they would have provided the basis for a punitive damage claim if Mrs. Ashley had lived. And the court held that that right to pursue punitive damages remained. They don't even mention Atlas Properties, which is to the same effect. On Barnett, I'm quoting from the case.
Counsel, I'm sorry to interrupt you, but in Atlas, it says here that the clear language of what was then 4511 says no action shall die with the person.
I think if you look, there's an ellipse there at one point in the opinion, and the governing statute that applied at the time has been amended in 1967 or 65 and says no cause of action shall survive. That is not the statute that was in play actually in the case, and that is not the statute that exists today. I'm looking at Barnett now, and remember, 4 dead, 1 living. The elements of a cause of action in tort are legal duty, breach, injury, and damages, plural. They say this case helps them. I would just urge the court to read what the court wrote at page 515 when it embraced the definition of the word arise onto the second textual point here that we are urging on the court. And this is what it said. The claim or judgment arising out of the same incident or occurrence and the text use of the word arising out of are also best understood to include the immediate injury causing event, not the negligent omissions that were relied upon by the plaintiffs in that case.
Well, but it one wasn't the issue there really about, had to do with an incident. And the connection was arising from an incident.
Right,
And so
right,
textually, it's a little distinct from what we
It
get
is
here.
distinct, but if you apply the Fifth District's reasoning and counsel's argument to the facts of Barnett, if the injured child had later died, would this court have really held that a separate cause of action had come into being, I'll say, instead of arising out of the same incident? It would not have, because the effect would have been that there would have been at least one additional statutory cap changing the state's exposure. We haven't heard a word today from a textual point of view, which I submit to the court is striking. We haven't heard a word today about the Fifth District's substitution of the word accrue for the word that's actually in the text, which is arise. They have their reasons why they say that arise doesn't apply, and it relates to some concept that arise means where something happened as opposed to when it happened. If that's true, why is the Third District in Meehan and why is the Fifth District in this case relying on that definition of the word arise to refer to temporal elements? The reason is because arise can absolutely have a temporal element to it. And that is clear if one looks at the entirety of Chapter 99-225. The best example
Well,
of
we know arise can refer to something temporal. I mean, that's the whole statute here.
Right.
I mean, and obviously that occurs, but
Right.
I don't think anybody's disputing that. I mean, I haven't heard that.
Well, I think that they are, because they are suggesting that the cases that we refer to, which use the word arise, only refer to the origin in the sense of a contract or a state in the case of the statute.
Counsel, they actually gave you more time than I told them to. You got 6 minutes and you're about to go into that. So you can sum up in the next 30 seconds.
I would just urge the court from a textualist point of view to take a look at Chapter 99-225 and the statute of repose. And I will conclude with this. It provides, under no circumstance may a claimant commence an action for product liability, including a wrongful death action, not cause of action, or any other claim arising from personal injury. And that's the way that this statute, this act, uses those terms. These causes of action arose most respectfully from a lung cancer no later than 1994, and certainly perhaps as early as the 1980s, when the conduct in question had terminated, at least vis-a-vis my client. For those reasons, thank you, Your Honor. We urge the court and ask the court to quash the decision of the Fifth District. Thank you.
Okay, thank you, counsel. We thank you both for your arguments in this case today. The court will now stand in recess for about 10 minutes. with the consideration of the third case on today's docket, Allen versus the state. Counsel?
May it please the court. My name is Victor Holder. I represent the petitioner Reggie Eugene Allen. This case is here because the First District certified a question as to whether sexual battery on a child 12 or older, but less than 18 years of age, is a Category 1 lesser offense of capital sexual battery. Due to the, as I explained in the brief, due to the version of the statute in effect at the time of the offense, the proper charge to be considered is sexual battery of a person 12 or older with no upper age limitation. Petitioner takes the position that regardless of whether the court finds that it is a Category 1 lesser included offense, a Category 2 lesser included offense, or simply a lesser degree offense of the charged crime of capital sexual battery, petitioner was entitled to the jury instruction because the evidence in the case supported the instruction. In short, this is not a jury pardon case where the defendant sought a lesser that was not unsupported by any evidence at all at the trial in the hopes that the jury would simply pardon him. Here, there was a legitimate dispute over the age element.
Well, counsel, let me ask you here. Was the argument below focused on, both in the trial court and in the district court, on whether
of the evidence?
Well, so beyond that, this really hasn't been teed up for us to consider the other things you talked about, has it?
Well, I would say that given that this court has always held this reversible, it previously held that it is per se reversible error to deny a lesser included, whether it's a Category 1, Category 2, or a lesser degree offense, where it's requested and there's evidence to support the offense, that is per se reversible error. We have a request for the instruction at the trial level, and the trial court determined erroneously, in our opinion, that there was no evidence to support the giving of a lesser instruction. So even if he had said specifically under the theory it's a Cat 1, a Cat 2, or a lesser, the judge would have denied. It would have been futile either way, because the judge found there was no evidence to support the lesser offense. And as we know, based on Rule 3.510 and 3.490 of the Florida Rules of Criminal Procedure, evidence is required. You can't have an instruction on those offenses without evidence supporting them.
What evidence is there in the record that any of the criminal conduct alleged happened after the date on which the victim turned 12?
If I may, I have some notes here, and I can have the citations to the transcript on the trial as well. So the victim could not testify to any specific days, years, or months in which each of the 3 charged sexual batteries occurred. And that's trial transcript page 60 to 62. She testified she was born in 2001. That's on trial transcript page 42. She testified to the location and the details of each offense and how old she believed she was at the time of each offense. She testified.
I'm not sure I'm hearing an answer to my question there. What is the evidence that any of the charged conduct happened after the date she turned 12? It's not even in the indictment, is it?
Well, the evidence is at trial in the form of the mother's testimony. So the daughter, the victim, testifies that the first incident of sexual abuse in count 1 occurs at the Williams residence at night in the living room while she and the defendant are watching Law and Order on TV, on page 45. She testified she's 9 years old at the time. The victim's mother testified that at the Williams residence, they moved to the residence in 2014, which would put, given what the victim testified as to her date of birth, that would put her age at either 12 or 13 when they lived at the Williams residence. So right there's a conflict in the evidence as to the age of the victim at the Williams residence where she says the offense in count 1 occurred. Next, there's the defendant who testified that neither the Williams residence nor the Aztecs residence had a TV in the living room, and he only started watching the show Law and Order once he lived at the Sims residence. and that he never watched it at the Williams residence. That's from 145 and 149 through 150 in the record. So once again, that places the possible commission of the crime not just at the Williams residence, but at the Sims residence, where the details of the crime fit according to the defendant's testimony. And the victim's mother testified that they moved to Sims in 2015. That's page 107 on the record. So again, based on the victim's date of birth of 2001, that would make her either 13 or 14 at the Sims residence. The victim herself testified that she was 13 at the Sims residence. And that's page 50. And both the victim's mother and the defendant testified that the victim accused him of sexual abuse at the Sims residence on page 108, 151, and 168. The victim's mother testified that the allegations were made in 2014 or 2015, while the victim was either 13 or 14. And that's 108 to 109. And then this was a disputed element in the trial because the defense attorney argued these discrepancies in closing argument and asked for the jury to return acquittal based on reasonable doubt. So given that there was evidence to support the instruction, whether we decide it's a category 1 lesser, a category 2 lesser, or a lesser degree offense, because there was an evidentiary basis in the record at the trial that the age was in dispute and could have supported a lesser conviction, it was reversible error for the trial court to deny that requested lesser.
I think maybe I'm just not following your exact argument as to, let's just talk particularly about count 1. So count 1 had a very specified date frame, correct?
Yes.
Okay. And was the child under 12 throughout that entire date frame of that?
If we accept the victim's testimony that she was born in 2001, then yes, during the full time of count 1 that's charged in the information, she would have been under the age of 12, yes.
So it would have been impossible for the jury to have found that she was over the age of 12 during that particular time frame for that particular count.
Only if they ignored the evidence that was testified to at trial, which was that she was not that age at the locations where she said she testified. Yes, I understand that in the information, it limits it to a specific date range. But in general, the state always has the option to amend as long as it's not going to cause undue prejudice. Had they testified, oh, it happened a day later, the state could have easily moved to amend and we'd be in the same position we are. So under this court's precedent, it's always been reversible error to fail to instruct on a requested lesser when there's evidence to support. Given that there's evidence to support here, we are of the opinion that it was reversible error. Now, this is not a fundamental error case like Knight, where we have to show that the failure to give the lesser vitiated the fairness of the trial, or whether the trial was fundamentally flawed. This is not an ineffective assistance case like under Sanders, where we're alleging that due to the failure to request the lesser, he was deprived of a fair trial. This was a preserved, requested error, complied with contemporaneous objection rule, so that the burden is on the.
Mr. Holder, a question. I recall when I sat in trial court in criminal, we tried a lot of these cases, the charging document, because children obviously are not taking notes as to when the date that these things occurred, especially when you're 9 years old or 8 years old. The charging documents stretch out the period as far as they can. It happened between actually 6-7 months times at a time. And in most cases, There were motions for bill of particulars requiring the state to narrow down the time so they can properly defend the defendant. But that typically was denied, basically because children can't remember. So if you have a situation, and I had the situation where the difference in date between 11 and 12 birthday, where that makes a big difference in the sentencing, if that falls in the middle of that period in the charging document, and the state presents evidence that no, it must have been before the 12th birthday, and the defense presents evidence, no, it must have been after the 12th birthday. Would that conflict in evidence justify giving an instruction on a lesser charge of someone to be convicted under 11, over 12, I mean?
Absolutely. If there's evidence presented that the child was over 12, or even if the evidence that she was under 12 is weak or subject to credibility problems, then absolutely that would justify the giving of the lesser.
See, because what I'm getting here is that just because the state charges it and the young victim comes in and gets the best shot she can, and regardless of the fact that mom comes in and says, it couldn't have been when she was 9, she was like 12 years old at the time. And that conflict there doesn't justify a lesser.
Well, see, we would argue that conflict does in fact justify lesser, and especially in a case where, as the victim testified, there is ongoing abuse over a series of a long period of time. She testified in the trial that Mr. Allen had sexually abused her over 20 times over a long period of time. So very difficult to say in a situation like this, this happened from between this day and this day, listing a period of years, but not also acknowledge the possibility that it could have happened just outside of that period of time.
But I think the certified question is as to whether or not this lesser is a necessarily lesser offense. That's the issue. And I don't know that it is. I mean, I think it should be given if, like in these factual situations I've just talked about, there's conflict in the evidence and both sides are presenting evidence to be decided by the jury on the issue of the age of the victim. But I don't think it's required just because you happen to be charged with the offense that you have to get that lesser offense.
I agree. I agree that there under the Sanders definition for subsuming elements of a necessarily included offense, it's difficult to say that this offense, the sexual battery of a child 12 or older, is a necessary lesser included offense because of the binary nature of the age requirement. Because the age is not always subsumed, because of the numeric value of the offense, the age is not always subsumed in the greater offense of capital sexual battery. I acknowledge that under Sanders.
Okay.
However,
isn't it true, having established that, which I thank you for clarifying, isn't it true that this case is different from, say, a necessary lesser included offense involving a quantity of drugs, say, where it's sort of a one-way ratchet, and as you go up, you wind up having a greater offense. Isn't age different? Isn't the right way to look at this case, having established that it's a sort of a binary thing, either you're under 12 or over? Isn't this more about a special class of victims? Isn't that the right way to look at this case? Either we find that the defendant in this case was a member of a special category that the statute identifies and defines and protects, or wasn't at the time of the offense. It seems to me like this isn't at all about an increasing quantum of something, but that age doesn't work like grams, like mass. Either you're a member of this class or you're not. Is that the right way to look at this case?
I disagree, because as grams do increase, so too does age. And
yeah, but let's run that argument out. If in fact it was a one-way ratchet, right? And we said, well, then the older you are, the less guilty you ought to be. The statute doesn't really hold that, right? If there was a sexual battery of an 85-year-old or a 90-year-old, the statute actually would treat that differently, right? It's different from kilograms of narcotics. Wouldn't you agree?
Well, no, because they're setting out statutory elements that are based on a numeric amount, just like possession of more than 20 grams of marijuana versus possession of less than 20 grams of marijuana. Or maybe perhaps a more pleasing analogy would be that if you are accused of stealing, I believe I referenced it in the briefs, accused of stealing an antique vase of some sort that's worth over the threshold for grand theft, that's a subjective value amount. There's no like lesser included incremental amounts.
Is it your position then, Mr. Holder, that the older the victim, the less culpable the person is under Florida statute? All the way, like, you know, that as someone gets older and older and older, it's just the statute gives less culpability to that? I mean, doesn't the statute categorize the aged and infirm as well as children as special victims for sexual battery or other purposes?
Well, of course that if this case involved an older person, that statute would apply, but I don't see how that particular statute would apply here. This is a question of whether or not the victim in this case was 12 or older, or whether there was evidence.
I'm not talking about the statute. I'm talking about the principle. The principle is that if your analogy, if we accept your analogy, that age is like mass, and that the more of it that there is, the less culpable someone is, and that's the statutory design here. It would seem to me very hard. It'd be very hard to square your analogy with the reality of what Florida law is. This seems to me more like a clear effort in the structure and text of the statute to protect a class of victims, namely children under 12. And either it's a binary thing. Either you are or are not a member of that class.
Yes, but the statute has also assigned a different punishment, a different degree of culpability for the offense based on the age of the victim. So it's a it's a punishable offense by automatic life if you're under 12, and before 2014, it was a second degree felony above 12. And yes, at some point, there is an age range on the top, perhaps a 65 or something. I don't know the answer off the top of my head of what the upper age range would be, but I don't see how it applies here.
Counsel, you are now well into your rebuttal with our assistants again. I will give you 2 additional minutes for rebuttal, but you need to decide whether you're going to keep going or not, because I'm not going to give you any more.
I will stop here and reserve the rest for rebuttal.
Thank you. All right, Counsel.
Thank you, Your Honor. Good morning. May it please the court, my name is David Welch, and I represent the state of Florida in this case. To start, to address the certified question from the first DCA of if sexual battery is a necessary lesser included offense of capital sexual battery, as we laid out in our brief, the state's position is first DCA got it right in this case, in that sexual battery is not a necessary lesser included offense, as Mr. Holder was speaking about earlier. Age is a binary choice. In this case, between capital sexual battery and sexual battery, you have a mutually exclusive age requirement, as the court's already been speaking of this morning. You either are over 12 or you're under 12. You can't be both. And additionally, using the statute as it existed in 2011 for sexual battery over 12, you'd also have an additional element of consent, which is not present in the capital sexual battery.
Let me ask you, just so we can be on the same page. When you say it's not necessarily lesser included offense, meaning that if it is proven without any conflict in evidence that the young victim is under 12, say 9 or 10 years old, once that is proven and there's no evidence contradicting that anywhere, then the judge does not have to give a lesser offense.
Yes, Your Honor.
Agree
yes.
that? Now,
Yes.
what if there is conflicting evidence? And especially if a mom comes in and says, no, she wasn't 9, she was 12. What if we have that?
Then you would potentially have a permissible lesser included offense, and
exactly.
Count 3 of the present case is a good counterexample. Whereas count 1, the date range charged was from March 25, 2010 to March 24, 2012. that the last day was the last day that the victim was 10 years old. Count 3 in the case actually picks up the next day and continues through March 24, 2014, in which she was over 12. And in count 3, the judge did agree and did give the sexual battery as a lesser included offense, because you had a date range that covered from when the victim was under 12 to when I think she was 13 in this case. So that's a good counterexample. Yes.
And I thought the law was such that in order to have the jury instructed on a permissive lesser included offense, two things had to be in play. First, there had to be some evidence that would support each element. But second, the charging document also had to charge each element of the lesser offense. Am I incorrect in that?
No, Your Honor, you're correct. And that was my point I was making earlier about, especially under the 2011 statute, that the sexual battery of over 12 would also include the additional element of consent or not. And that, again, was not charged in count 1.
So in this case, this should not have been given for the reason that the charging document did not allege the age of the victim as over 12, irrespective of what the evidence showed.
Yes, in this case, the court was operating under the up-to-date statute, and as I think we've already talked about, it should have been under the 2011 statute. But then to address, I think the United States Supreme Court has said basically you're entitled to any lesser included offense in which the evidence supports. Here, you had the victim testified that she was born on March 25th, 2001, and there was no evidence to contradict when she was born. I mean, she was testifying she was 17 years old. So to briefly address the reply brief, there's not really a lot of evidentiary value the jury could have gotten of trying to judge her age based when she was testifying. In terms of the question in the evidence of how old she was when she lived where, that would have gone towards guilt or innocence on count 1, not necessarily if she was over 12 or under 12, because as it was charged, she could not have been over 12 years old. And I'd point this court to an earlier decision from Lynch v. State, of Florida Supreme Court decision from 1974, in which it talks about an instruction indicating that the jury could convict appellant for committing the crimes, even if they found the crimes occurred at a time outside the statement of particulars, invited the jury to tread on impermissible territory. So based under the appellant's theory, if you were to give a sexual battery instruction for count 1, it would necessarily imply that the offense would have occurred outside of the dates charged in this count, because it was impossible for her to be over 12 on the date range charged. And the purpose of jury instructions is to help the jury come to a conclusion of the case, not to confuse the issues by instructing them on an offense that was factually impossible for the appellant to commit based on the charging document. So here, as I stated earlier, the state's position is the first DCA was correct in that sexual battery is not a necessary lesser included offense of capital sexual battery because of the mutually exclusive age elements. It is a permissive lesser included offense, as demonstrated by count 3, where you had a situation that covered both when the victim was under 12 and she was over 12. And as we mentioned earlier, because of child testimony, they're not, unless they're keeping a journal or something like that, they're given date range, estimated date ranges. So you have cases where potentially you would cover both under and over the where the statute falls. And you also have cases like this where count 1, she was 10 when the count ends. It's just not possible for the appellant to have committed sexual battery in count 1.
So in that sense,
let me ask you this. Let me ask you this kind of practical question. What would be wrong with a rule that says to simply, if there's evidence to support a particular that a particular offense occurred, that the jury would be instructed on it? Because it seems like to me, in this case, there's this conflict in the evidence about how old the child was under count 1. When the the underlying conduct or the offense that occurred. There's evidence about a dispute in the evidence about how old she was at that time. So it puts the jury in a position of, okay, we think potentially thinking, well, we're sure this guy did this. We're not sure when he did it because of this, but we've only got one choice. So, since we're sure he did it, we'll go with the choice we got, as opposed to thinking, well, we're not sure about when he did it because of this, so we'll go with the more lenient choice because of our doubt that it occurred during this time frame. But respond to that.
Well, my response would be there would be nothing wrong with a rule like that as long as there was some evidence to support the lesser included offense. And in count one, there simply wasn't. Now, whereas there's a dispute here of, how old the victim was when she lived in specific houses or not, and then the described conduct. The fact is, count one still had a very specific date range, and her date of birth itself was not.
Well, I understand that. But when you say that, but there's a dispute in the evidence about how old she was when she lived at the place where she claimed that this particular act had occurred. Correct?
Yes.
Well, I don't.
Mr. Welch, isn't the answer that historically we've said that due process prohibits a conviction for an uncharged crime and submitting an uncharged crime to the jury. So if they are mutually exclusive crimes under count one, then the state would have to successfully amend the information in order to get generally a jury instruction on what is a separate crime based on the defendant's age. Isn't that the way it normally works?
Yes, Your Honor. And for example, if it had been a capital sexual battery charge without a date range, and then the defense had requested a bill of particulars and then had a date range specified, the state would be locked into proving the crime occurred during that date range. This case is maybe not the best example just because you had count one that covered a specific date range, and then you also had count three that picked up. So that's where there's the dispute and evidence of when the crime occurred and where it occurred. That now is the jury's job to decide on what they believe occurred beyond the reasonable doubt. And if they didn't think it, based on the evidence that it occurred at the address she was testifying about when she was still under 12 years old, their duty would have been to acquit on count one and then potentially convict on count three if that's when they believe the evidence showed that the conduct occurred. If it had got to the point where they just threw their hands up and were like, we don't know when this happened, potentially.
Well, if there was a reasonable doubt based on all the evidence as to her age at the time, then they should have come back with a not guilty. Correct.
Yes, sir. And that was the point
but here's the argument. Then we're conflating two different things. What you're saying is, and what Justice Lawson mentioned is, if the indictment locks in the date, meaning that she could not have been 12 the way it's charged in the indictment, despite the fact that there's evidence presented during the trial that she may have been over 12, the only thing left for the defendant to do is argue to the jury, look, the state told you she was 11. She wasn't. Therefore, you got to find her not guilty and ignore the fact that she was, molested or whatever, that kind of thing. Despite the fact there's conflicting evidence, if you had the second lesser charge, defense could at least say to the jury, you can find her guilty of this one instead of that one. What you're presenting basically is an all or nothing situation to a jury that just heard an horrendous and sure evidence as to what happened to this poor child. And that's not going to work.
Yes, Your Honor.
One way or the other.
I agree with that, Your Honor. And that goes back to that Lynch v. State case that I was citing earlier, that we can't be we're not supposed to be in a situation where we're telling the jury that they can convict the defendant for a crime that is outside of the charged time frame.
Right. So let me just to be clear though, because you're giving this kind of muddled answer to Justice Lawson and Labarga. If with absent an amendment to the indictment, it's not even a permissive instruction in this context, because you would be instructing the jury to convict someone of something that's not charged, i.e. a crime on someone 12 or older.
Yes, Your Honor, that is correct. And I apologize, jumping between count 1 and count 3, where you have two separate situations. Here,
it would be for the defense, it would be all or nothing.
Yes.
No lessers. They didn't prove the right date. Therefore, you got to find them not guilty.
Yes,
That's the only defense it would have.
Yeah, because the element is that the victim was under 12 years old. The state has to prove beyond a reasonable doubt that the victim was under 12 years old. And if they don't do that, the correct response is for the jury to acquit on that charge. And unless any of you other ladies or gentlemen have any questions for me, I don't have anything else to offer at this point. I just ask that the court find with the first DCA that the certified question is that sexual battery is not a necessary lesser included offense of capital sexual battery. Thank you.
Thank you, counsel. Rebuttal argument.
Yes, quickly to Justice Lawson's question, putting aside if you can't have the lesser under Cat 1 or Cat 2, you can have the lesser as a lesser degree offense to the offense that was charged. So even though they've charged capital sexual battery, you're entitled to have the lesser under 3.490 because it's the lesser degree of the offense. And there's case law that says when a defendant is charged with, say, murder 1, he's on notice that he's also charged with the possibility of murder 2, manslaughter, etc. So that is how you get the offense instructed upon, even when it's not specific, where it may not be a Cat 1 or Cat 2 lesser. It's still a lesser degree of the felony. To Justice Kennedy's point, yes, a jury given no lesser, there's an extreme danger that they are going to convict because they believe that the defendant has committed a sexual battery of a child. They're not going to acquit because they're not sure whether the child is 11 or 12. And they're not going to acquit because the charge range is maybe outside of the date range when they're sure beyond a reasonable doubt, as they were here, that the defendant raped a child. I don't think it's realistic, and it's a danger that's spoken to by the U.S. Supreme Court, by this court, by federal courts. This court in Justice Shaw's dissent in Wimberley says a lesser instruction has a legitimate purpose to protect a defendant's right to be free from miscarriage of justice. It gives the jury the true verdict choice. Justice Kennedy, your dissent in Haygood echoed Justice Shaw's recognition of the purpose of the lesser to prevent that miscarriage of justice. It also allows the jury to maintain its role as the ultimate fact finder. The jury is the one who decides what evidence is reliable, what evidence is not, who's credible, who's not. So the idea that overwhelming evidence on one particular charge defeats a lesser included request is invalid under this court's precedent. The state brought
So
up
you've now exhausted your time. Could you sum up in about 30 seconds?
Yes, Your Honor. Regardless of whether the sexual battery of a child 12 or older is a Category 1 lesser, a Category 2 lesser, or a lesser degree offense of the crime charged, capital sexual battery, petitioner was entitled to the jury instruction on the offense under this court's case law because there was evidence of the offense and he requested it timely at the trial. We ask that the court reverse and order a new trial on count 1.
All right, we thank you both for your arguments in this case today, and we will now prepare to move on to the final case on today's docket.
I'm Joe Jaco with the Gunster Law Firm, representing the city of West Palm Beach. I'd like to reserve 2 minutes for rebuttal, and if I may, reserve that time after the amici time.
Yes.
Thank you. Our appeal is to resolve a decisional conflict between the 4th District in this case and the 3rd District in Duternay versus City of Coral Gables, as well as the 2nd District. I intend to cover 3 points at issue. First, the 4th District's incorrect reliance on voucher special damages standing. Second, the zoning ordinance's enforcement is discretionary as discussed in Trianon. And third, this case is non-justiciable as a matter of separation of powers. This is an unusual case, but an everyday concern for municipalities. The Havers complained to the city of West Palm Beach that their neighbor was violating a zoning ordinance. The city investigated and found no violation. Yet the Havers sued the city for equitable relief to have a court force the city to enforce its zoning ordinance. It's important to note the Havers have a remedy. They sued their neighbor for her alleged violation, and then they dismissed that lawsuit. But if the 4th District's decision is upheld, citizens will sue the government anytime they disagree with a code violation or a code enforcement officer's decision. That Pandora's box needs to be closed by reversing the 4th District.
Counsel, can I ask you a question? So to what extent should we view these decisions kind of in the abstract under the category of, enforcement decisions and enforcement discretion versus looking specifically at the text of whatever the governing sort of charter or ordinance would be and seeing how much discretion the text itself leaves or doesn't leave for the enforcing officials?
Your Honor, so in the cases of this court, there is certainly an understanding that the police powers provide discretion, right? Discretion to enforce the law, whether it be an arresting officer, whether it be a code enforcer or some kind of inspector. So that's the starting point. But certainly that discretion can be cabined by the law. And so in this case, if there had been an allegation of some statutory right, constitutional right, some other provision of law that cabined the discretion, then that may make it a justiciable issue. In this case, not only is there no allegation of that kind of right or any violation of the law, but the ordinance itself says that where the city determines a violation. So the ordinance itself acknowledges the discretion it's using.
And so in this case, if let's say that there were evidence, in this case, the complaint, which we have to operate under that, it says that the report basically didn't say that there was a violation. So it seems like on the, just the face of the ordinance, it doesn't trigger any of the shall language. But let's say that there were, the complaint alleged that the inspector here had found a violation, documented the violation, sent his report, to the Havers. And then we're left with this, upon that, then the enforcement entity shall do X, Y, and Z. Would our court have the authority to compel the enforcement authority to do X, Y, and Z?
Your Honor, so if the ordinance had cabined its own discretion, and let's say, as you mentioned, one of the shalls were violated. So the violation is found, and then there's, as the ordinance says, the city shall notify the violator in writing. So that doesn't happen. Then there could be an allegation that the city is violating this ordinance. And that could be a question of interpretation that could go before a court. That could be a justiciable matter. But it would have to be an asserted violation of the law or some other right that the Havers were provided or asserting that then the court could adjudicate as a legal determination, as opposed to just telling the city how to use its own discretion.
Counsel, given what you've just said, isn't this really something like a takings case? Doesn't the justiciability of the case depend on whether the alleged violation works some sort of taking of the haver's property by the government, either by enforcing or not enforcing it? Isn't that the lens through which we should be looking at this? And if it's not, you know, a lot of these cases in, you know, the sort of zoning or regulatory context apply that as the lens for justiciability when it comes to the exercise of a local government's discretion. Is that an analogy that makes sense from your perspective, or is this, should I sort of put that to one side and look just at the text of the statute?
Well, I think so, Justice Correal, but in this case, the court seems to be hung up not on the justiciability issue, but on the standing issue. They're not even getting to the justiciability issue in the Fourth District's opinion. The concern is the voucher precedent clearly lays out when you have special damages, you have standing, and we don't dispute that. Our argument is that there's another secondary or subsequent consideration by the court of once you have standing, is then the case justiciable? So Mr. Haver may have special damages, but if he hasn't asserted a violation of the law, something to take this out of the discretion of the city, then the case is still with the city and not before the court for its determination.
Doesn't our readings though, so it's almost like you're saying that if the ordinance is mandatory enough as to what it tells the enforcement officials to do, it still seems like there's this other step of us kind of reading a private right of action for third parties into this. And doesn't that raise separation of powers issues too? I mean, why do we, I'm just, where do we get the authority to do that? And in this case, where do we even have the authority in this realm to allow third parties to sue, to enforce ordinances directly against, you know, the neighbor, for example?
Yeah, absolutely, Justice Muniz. I mean, there's no private right of action, third party right of action here. I mean, even the Fourth District in dismissing a writ of mandamus recognized this isn't even a ministerial duty, right? This is a discretionary duty. So it does remain with the city. And let me be clear, it's not to say that the Havers don't have some remedies, right? They did indeed sue their neighbor and chose to dismiss that. They certainly could, you know, go before the city council, the mayor. They could, you know, operate in the realm in which this matter is still resting. But until there's a legal determination to be made, it's not properly before the courts.
Can I ask you about this whole issue with the AG and the separation of powers thing? Can we decide this in terms of the judicial, in terms of the extent of the judicial power under the Constitution without blending that into the quote unquote separation of powers clause?
Absolutely. So as I understand the AG's argument under Article 2, Section 3, the branches that are given separation of powers are the distinct state branches. We're not arguing that the city has the same legislative authority as the House and the Senate, or the same executive authority as the governor. Our argument is that the courts, the judiciary as a state branch, doesn't have the ability to intrude on a matter that is not yet a legal matter, but is still one of policy making and of discretionary judgmental decision making at the city, at a municipality. So I think those are very consistent. I think that this court could certainly say that this case is non-justiciable in recognizing separation of powers, but for a different reason, for the limits of the nature of the judiciary, as opposed to imputing some legislative or executive authority onto the municipality. If the court doesn't have any other questions, there's one thing I would like to address before concluding, and that is The Fourth District relies pretty significantly on the dissent in Deterne, which is the dissent by Judge Lagoa. And while certainly Judge Lagoa recognizes that Boucher, Renard, and their progeny provide special damages, in all the cases that Judge Lagoa's dissent cites, there was also some violation of the law. So in addition to there being special damages that a city or a county may have created, the city or county also did something else. Yeah, they violated some setback requirement for buildings, some public notice requirement. They misinterpreted an ordinance. There was some allegation of a legal violation from the city. In this case, we don't have that. We have just the pure desire to have the courts enforce the ordinance, even though there are special damages, but no violation of law. And I think that's critical in distinguishing between the dissent to Deterne and the Fourth District not noticing or addressing that distinction in this court's case law. So to be clear, we would see that the Boucher and Renard case law would have its full effect. And at the same time, the court recognized the justiciability principle that's addressed in Trianon and as well as I think understood in commercial carrier, Wallace v. Dean, and subsequent cases of the court.
And just to be clear, in this case, you're not disputing that the allegations in the complaint are enough to satisfy the special damages test for standing. I know you make the distinction between that and justiciability, but you can see that the allegations are sufficient on that prong?
That's right. That's right. If the court doesn't have any more questions at this time, I'm happy to reserve whatever time you wish for rebuttal, certainly the 2 minutes, and if additional time's needed, Mr. Chief Justice, at your discretion.
Right. We thank you. Mr. Haber.
Good morning, Your Honors. My name is Peter Haber, and I'm representing my wife and myself in these proceedings. I apologize to the court. I'm a commercial lawyer and have a corporate lawyer's voice. In July of 2018, our neighbor who lives next across the street from us, who I'll refer to as a code violator, started to operate what's known as an adult family care home, which resulted in her violating the single family zoning classification because she had more than 2 unrelated people in her home. After exchanging correspondence with the city of West Palm Beach, my wife and I filed a complaint against the code violator, the city of West Palm Beach, and 2 of the city of West Palm Beach employees who are responsible for code enforcement. In May of 23 of 2019, the trial court dismissed all of our 5 counts on the basis of the Third District Court's decision in Deterne versus the city of Coral Gables. And then on June 10th, the Fourth District Court of Appeal reversed the trial court's decision with respect to our counts 1, 2, and 3, which were for injunctive relief against the city on the grounds that the Deterne decision violated this court's precedent in Boucher versus Nevada.
Counsel, would you mind, can you hear me okay? My audio wasn't working earlier.
Yes, I can.
Okay, perfect. Would you mind if I just kind of interrupted you with a question about the Fourth DCA's approach? If we were to adopt that approach, which is the position that you've advocated, what would the trial court's order look like that directed the city to enforce this discretionary sort of action? Like what would that look like? What would it entail? Would it give the city very specific instructions? Would it limit, the city couldn't settle? Would it say you must impose a fine? Would it say you must fix the problem in a particular manner? Like what would the order from the trial court
in your mind, entail if we adopt the Fourth DCA's approach?
Well, actually, Your Honor, we addressed that in count 2 of the complaint, where we asked for a declaratory judgment that would require the city to comply with West Palm Beach Ordinance 9434B, which requires, in the case of a violation of the zoning ordinance, that the city take certain mandatory steps. So we're piggybacking off of that ordinance, the 9434, which sets out very clearly what the city has to do. There are several steps when there is a zoning violation.
And so the order from the trial court would simply lay out these mandatory steps without any additional discretion given to the city.
Yes, because this particular enforcement provision, the 9434, which says what the city has to do when there is a violation, doesn't allow for any discretion. I did some research to try to find out about the origin of that particular enforcement ordinance, and it seems to have come out from model law, which was designed to take the discretion away from the cities when there is an actual zoning violation.
Mr. Haber, I can appreciate your argument and understand it, but what I'm struggling with is, from what I read, that the city did not determine that a violation exists. Had they done so, I could see where the mandatory aspect of the ordinance would require further action on their part, pursuant to your relief sought in the case, or pursuant to a mandamus. But the problem that I'm struggling with in your case is that the city did not find a violation. Help me with that.
Well, I can't, Your Honor. I'm struggling with the same issue. The problem is that the city's taken a contradictory position. In their initial briefs at the trial level, they said, we've taken no action. But then counsel for one of the zoning inspectors stood up and said that the zoning inspector had gone to the premises and found that there was no violation, because at the time there was only one person in the home. The elderly people were out seeing doctors, and then again in the recent in the briefs that were filed with this court, they switch gears again and then say that there was a determination, and there was a determination that there was no violation. So I'm as confused as you are.
Mr. Haber, let me ask you this. Why wouldn't a remedy directed at the offending neighbor be sufficient to resolve this sort of controversy and arguable wrong without ensnaring the judiciary and ordering officials of government to do things where they've just decided to keep their hands off of it?
The answer is because she's tricky. We did sue her, but she is a very determined. She's apparently in some network that ran these adult family homes, and they would switch people back and forth as soon as there was a problem. And we realized, and this is impolite, but she's also willing to manipulate the facts. And we were in a position where civil discovery was just not going to get us very far. And we really needed the police powers of the state to be able to go in there without notice and identify exactly how many people were there. And that we just gave up on the civil cause of action against the code violator. And also we thought, we got counterclaims from a large law firm that was representing her on a pro bono basis, accusing us of being racist because the code violator is Cuban. And we were facing this massive litigation. And my wife and I decided, hey, isn't this really the job of the city of West Palm Beach to enforce their own ordinances? Why should citizens have to spend their own resources to do this? especially when it's in civil litigation context, it's very difficult to do so. So I'll continue on. And what this court did in the Boucher cause of action was to create a symmetrical cause of action, which allows victims of zoning violations to sue the perpetrator to enjoin the violative conduct, but at the same time to also sue the city to compel the city to enforce the respective zoning violation. And this new cause of action has two elements. You have to show that there's a zoning violation, and you have to show special damages. Special damages is a very interesting concept. You have to have a particular damage which is not shared by the public at large, and it addresses the issue of standing. But it also, I think, puts a jurisdictional constraint on the courts, which is going to prevent courts that are adjudicating the Boucher cause of action from doing it in a purely public realm. And Judge LaCoy in her dissent really picks up on this sort of double function of the special damages. It's not only standing, but it was to address the possibility that if the action were adjudicated in a purely public scenario, then there might be some risks of encroaching on the discretionary powers of municipalities. And there Judge LaCoy writes, and I think it's very astute. She says, in short, once special damages are shown, enforcement of the zoning ordinance is no longer an action purely within the discretion of the state. Now, West Palm Beach replies by saying, no, the court in Boucher did not create a new cause of action. It simply is a continuation of a cause of action which existed prior to Boucher, which is known as the ultra vires acts cause of action, which among other things allows an individual to sue a city for a violation of a zoning ordinance. And when West Palm Beach says, hey, but our refusal to enforce the single family zoning classification does not constitute a violation of a zoning ordinance, even though, as I mentioned before, ordinance of 9434B requires the city to investigate any allegation of a zoning ordinance violation and to take specific measures if it finds that there is a zoning violation. And I don't think there's anything discretionary about that. Inspectors have to go in and determine if there's a violation. Excuse me. And actually the holding is very clear in Boucher. It says that a victim of a zoning violation has an injunctive remedy, both with respect to the perpetrator, but also with respect to the city that did not enforce the respective zoning ordinance. And this understanding of the holding has been reaffirmed by this court in two subsequent cases. In Menard versus Dade County, the court writes, the Boucher cause of action was a suit to enjoin the violation of the setback requirements of a municipal zoning ordinance. And this understanding of the Boucher cause of action was again reaffirmed in the case Scads versus Albertsons versus ABC Liquors. Now, the majority of the attorney never even discusses Boucher, but Judge LaGoa does. She analyzes it in detail, and she writes, the Boucher cause of action addresses the issue of a private citizen's right to seek enforcement of municipal ordinances. Well, then West Palm Beach throws a head fake and says, well, even if Boucher doesn't require a demonstration of an actual violation of zoning ordinance on the part of a municipality, if Boucher doesn't require that, it's in violation of the separation powers and the doctrine of the separation powers, and consequently is unconstitutional. And to support that argument, it quotes from the Trianon versus the city of Jalea case, from what is known as the taxonomy section of that decision, which West Palm Beach argues gives the courts, gives the municipalities absolute discretion with respect to the enforcement of zoning codes and building codes. But the problem is that this court developed the taxonomy language not to analyze separation of power concerns, but to address whether or not cities' actions and decisions might give rise to a duty of care, which could expose cities to liability under tort law. Taxonomy language has nothing to do with the separation of powers document. And this distinction is made very clear in two of your precedents, Wallace versus Dean and Keisner versus Cole. Well, then West Palm Beach moves on and says, well, okay, maybe if the taxonomy language doesn't apply, nevertheless, our refusal to enforce the single-family zoning classification is a policy decision, and therefore it's protected from judicial intervention by the separation of powers doctrine. But they run into trouble there too, because this court has decided in its case, county commissioners of Brevard County versus Schneider, that the enforcement of zoning ordinances is not policy. It's the application of policy, and the application of policy is a quasi-judicial act and is subject to the court's review pursuant to the standard of substantial and competent evidence. But then West Palm Beach takes a step back and says, well, in any case, this alleged discretionary power to enforce zoning laws stems from our police powers, and consequently, this discretionary power should apply both to tort cases and injunctions. But I think that argument overlooks a fundamental difference between tort law and injunctions. In injunction cases, we ask juries to decide, does the city's acts and decisions possibly, are they unreasonable? And this court in commercial carriers said, wait a minute, be careful, because when juries start making decisions about the reasonableness of cities' acts, they might encroach on cities' discretionary powers and violate the separation of powers doctrine. But in respect to injunctive relief, particularly in the cause of action, we're not asking juries to decide that the city has acted reasonably. We're simply asking the jury to decide, was there a violation of the zoning ordinance? In this particular case, to determine an issue as simple as how many people were in the code violators house. Now, then they argue, well, okay, if the separation of powers doctrine does not prohibit the official cause of action, sovereign immunity does, because the Florida legislature's waiver of sovereign immunity in the 70s, they argue, only applies to tort law. So sovereign immunity remains in place with respect to injunctive relief. I think that argument fails to consider the actual origins of the doctrine of sovereign immunity. West Palm Beach seems to came to suggest that sovereign immunity comes out of constitutional principles, particularly the separation of powers. It does not. It is a doctrine that says people cannot sue the king, an old common law doctrine. And courts make common law they can interpret and apply it. And this court has interpreted and applied sovereign immunity even prior to the waiver of the sovereign immunity in the 1970s, and carved out exceptions to sovereign immunity with respect to municipalities, what's known as the municipal immunity body of law. And this court carved out, particularly didn't permit sovereign immunity to apply to what was known as proprietary functions. So what this court did in the Boucher cause of action, when it accorded adjunctive relief to victims of zoning violations, it did what it has done with respect to municipal immunity. It simply interpreted and applied the common law and found that it carved out an exception allowed victims of zoning ordinances to seek injunctive relief. Now, in conclusion, I would say this court, what it has done is to create a multifaceted construct that allows appropriate judicial review of decisions and actions taken by municipalities in zoning field. And what the court has done is created a continuum, and on the continuum there are four different kinds of actions, with different standards of review, and even different requirements for standing. And this continuum is set out specifically in two of your precedents, Renard versus Dade County, and also in this Scad Albertsons versus ABC Liquor. And what the court has done is that on the far end of one side of the continuum, where there's a lesser standard of review, which it applies particularly to the cause of action, which allows individuals to actually challenge policy and planning formulated by the municipalities. But all the cities have to do is show that it's not arbitrary under this court's fairly debatable standard. And then on the other side,
Mr. Haver, you're now have exceeded your time. If you could sum up in about 30 seconds.
Yes, I would conclude simply by saying that what West Palm Beach wants this court to receive from this sophisticated, multifaceted continuum, and as an alternative to apply a standard, very weak standard of review, which was traditionally reserved only for policy and planning, but they want you now to apply that weak standard to any kind of decision that the cities might make. And the result is going to be the legislature going to get its powers are going to be considerably diminished because the executive will have total discretion over the enforcement of zoning ordinances. Thank you.
Thank you, sir. Now I'll recognize the Deputy Solicitor General.
Thank you, Mr. Chief Justice, and may it please the court. Evan Ezra for the state of Florida. The Constitution's separation of powers clause applies to the branches of the state government, not to local governments. I want to be clear about what we mean by that. We do not mean that courts have open season whenever local governments appear before them. Instead, we mean that local governments are not co-equal branches of the state government with powers that cannot be invaded by the coordinate branches of the state government. So, for example, if state legislation applies to a municipality, the municipal executive cannot challenge the legislation by claiming that her own executive powers were violated by it. I think what we heard this morning is that petitioner now agrees with us, and we think that much is clear from the text of the separation of powers clause, which begins by talking about the powers of the state government, not the powers of local government. In turn, the powers it discusses are given to the state government in the vesting clauses of Articles 3, 4, and 5, and the branches it describes correspond to the structure of the state government, not to the structure of local governments. I don't think our friends on petitioner's side have argued otherwise as a textual matter, Instead, their argument, at least as I take it, is that if local governments are not thought to be included in the separation of powers clause, then courts would be forced into the business of legislating for local governments. But we don't think that concern is warranted for several reasons. First, and this is the point that you got at with your question earlier this morning, Justice Muniz, the separation of powers clause in combination with the judicial vesting clause in Article 5 is itself a limitation on a court's power, no matter who appears before it. That is, no matter who the parties are, the court is always limited to exercising the judicial power. And the judicial power, as this court has recognized in its political question cases, requires judicially discoverable and manageable standards. We think that view fully explains commercial carrier and its progeny. On our view, generally dictating government policy without some sort of positive or common law guide is outside the scope of the judicial power because there are no discoverable or manageable standards to generally set policy. Second, the separation of powers clause protects from infringement the state legislature's decision to allow local governments discretion in any area. Although it is true that local governments have default home rule powers, the legislature always has the choice to occupy the field and legislate for itself. In doing so, and I think petitioner agrees with us on this as well, the legislature could provide for standards that allow for review of local government decisions. But when the legislature does not do that, and when there are no background common law rules to apply, the legislature's decision to leave full discretion to local governments is itself a decision of the state legislature, which should not be invaded under separation of powers clause.
So is that the sense in which this is arguably a separation of powers case, that really the issue isn't the courts invading, the authority of the local government, but invading the state legislature's authority to have essentially allowed the local government to govern?
That's exactly right. The way that we would approach answering the questions in this case is to first ask, are there any judicially manageable standards that could be applied? And we think that question basically boils down to, is there discretion in West Palm Beach's decision to enforce or not enforce its zoning ordinance? If there is absolute discretion, we think, one, there's just no judicially manageable standards, which would make it a political question. And two, we think that that also reflects the legislature's decision to leave discretion in this area, which is itself a separation of powers concern.
And so in answering question one, would you stick to the text of the ordinance itself?
So I think that you would look to the text of the ordinance, but of course you would look to any interpretive canons that you could in deciding what that means. And so, for example, and I think petitioner may be better able to answer this than I can, but I think you would look to, for example, common law rules about what discretions exist in executive power in interpreting that text. But I do think the foremost consideration would be the text of the ordinance, yes.
So what is it? So what is your sort of worst case scenario of what we could say in this case that you would care about?
So what we care about is we think that there's been a little bit of a tension in this court's case law, with some cases suggesting that local governments have separation of powers rights in their own names, although of course the court has said the opposite in, for example, Locke v. Hawks. I think our worst case scenario is for the court to continue to emphasize, without any discussion of where the source is grounded, that the separation of powers clause applies to local governments. And so what we think that an opinion in this case looks like would clarify that no, local governments are textually excluded from the separation of powers clause, but would then go on to apply that analysis to the facts of this case. And then the court could explain that its cases like commercial carrier and Trianon are really supported by inherent limits in the judicial power or the state governments.
Do you agree that in this case, that if there had been a violation found by the city, that the rest of the language in the ordinance is mandatory to the point where the cause of action for mandamus would lie by the court?
I see my time has expired, Mr. Chief Justice, if I could answer that very quickly.
Yeah, please, you can answer.
Absolutely. So we agree with the way that you read the ordinance. We don't take an ultimate position on how that would come out. And I think the reason is there may be some common law bases that even though it says shall, petitioner could argue that there is still some inherent discretion left in the statute. But I just want to be clear, we don't take an ultimate view on one way or the other, whether there is any discretion.
But there would be, you don't argue that there's a lack of authority by the court to actually issue a mandamus in the event it found that it was mandatory.
So on our view, we don't think that there are any limits on the court in applying a non-discretionary scheme in a case like this. I think the question would be, is there discretion?
Thank you.
All right, thank you. Mr. Gibbs.
Mr. Chief Justice, may it please the court, Edward Geddes on behalf of the Florida League of Cities and the municipalities of Aventura, Pinecrest, and Cutler Bay, and for today's oral argument purposes, also the cities of Miami and Coral Gables and the Miami-Dade League, all of which are in agreement that separation of powers principles do apply when local governments are involved in the case. Now, listening to the court's questions and the argument of counsel in the case, I'm reminded of the unwritten rule applicable to amicus that says first do no harm. And we may be dancing on the head of a pin like an angel, trying to figure out what's going on with the clause. And to be clear, the contention of the amici is that separation of powers principles have application in cases that involve the exercise of powers by local governments. They may be characterized as being either legislative in nature or executive in nature. And for example, Article 8 of the Constitution, which confers home rule powers on municipalities, also specifically indicates that all municipalities are required to have elected bodies, right, that are legislative in nature. So therefore, they're going to be exercising legislative power. Could that power be preempted by the state legislature? Absolutely, under appropriate circumstances. So that's not the debate. Our concern arises primarily that the court issues a sweeping ruling at the Attorney General's invitation to state or to conclude somehow that separation of powers principles have no application simply because Article 2, Section 3 does not specifically mention local governments. And if the court is prepared to travel down that path, I would respectfully suggest that this is not the case to do so, because the issues have not been fully briefed. There hasn't been a full exploration by the parties, and that should not happen. But turning now to the merits of the Attorney General's position briefly. I understand the Attorney General's desire to couch the issues here in a manner that separates local government from Article 2, Section 3. And they call it justiciability, and that's fine. But I think the court should also recognize that the concepts of justiciability and non-justiciability don't exist in a vacuum. They arise from the wellspring of separation of powers, which is the foundation of American democracy, whether at the federal level or in the states. And that is the wellspring from which the concept of justiciability comes from. I think that the most articulate way I've seen it expressed is by Justice Gorsuch, when he said that the founders' design for separation of powers isn't just about how the powers are dispersed into branches, but also have implications for how they are exercised within each branch. And in layman's terms, that means judges shouldn't act as legislators, legislators shouldn't act as judges, etc. It's a basic proposition. And that is what we see in the second sentence of Article 2, Section 3, namely that no member of one branch shall exercise powers appertaining to the others. That captures the same concept. Now, we do not have a problem. We have no problem whatsoever with the resolution of this case that turns on a determination that the Fourth District erred in concluding that the dispute here was justiciable. The amici have no issue with that. Our primary concern is that in the process of reaching those decisions, and in light of the Attorney General's involvement, that the court not travel too far down the road respectfully and begin issuing pronouncements about how separation of powers have no application when local governments are involved.
So do you agree with the thrust of some of the answers that we've gotten today, to the extent that when the municipal government is acting in its legislative capacity and is sort of giving instructions to the executive actors in its, government, that it basically can't constrain that discretion without potentially inviting judicial scrutiny of enforcement decisions?
To the extent local legislation ties the hands of the executive, or the equivalent of the executive branch of local government, then yes, I think there are some potential issues that could arise. And if it's clear from the local legislation that lack of enforcement would result in a violation of the law, then I think, as my friend Mr. Jaco argued, you might end up with a mandamus scenario, which is why we drew the parallels between the mandamus proceedings and the proceedings at issue here in our brief, because we think the two bodies of law should be interpreted in a consistent manner. I see I've gone over my 5 minutes.
Some of them in about 15 seconds.
We would respectfully request that the court quash the decision of the Fourth District on by applying separation of powers principles and making a determination regarding justiciability, but decline the Attorney General's invitation to issue a broader ruling with respect to application of Article 2, Section 3 here. Thank you for your time.
Thank you. Mr. Jacob.
Your Honor, I'd like to hit 3 quick points in response to the Havers argument. First, the Havers admit that they went straight to the courts. And as we've discussed, there's a number of remedies they have: lawsuit against their neighbor, pursuing the city, administrative remedies under the ordinance itself. He mentions that the ordinance 9434B requires these mandatory steps, but he ignores the preceding sentence, quote, where it is determined a violation exists. And that's the discretion of the ordinance. Number 2, the Havers admit that they want the courts to direct the police powers of the state. And I think that's the sole concern here, the primary concern here, is that that discretion without a violation of law remains with the municipalities. And third, he makes an attempt to distinguish commercial carrier and Trianon in the application to this particular case. But if I may, I'd like to quote from Kaiser v. Cole, which Mr. Haver cited. And it says, quote, we ourselves repeatedly have recognized the discretionary function exemption is grounded in the doctrine of separation of powers, and the court cites commercial carrier and Trianon. So that principle of discretion under the doctrine of separation of powers is confirmed in both lines of cases. The cities certainly support the structural constitutional principles of separation of powers as they apply to municipalities. And they do in the sense that there is no judicial power for a discretionary action. And I think, to end, Your Honor, that is something that no one here disputes in terms of the amici, that the judicial power has its limits, and it's been reached in this case.
All right. Well, we thank all of you for the arguments presented to the court today in this case. That's the last case on today's docket. So the court will now stand in recess.